I am a fire and explosion lawyer. I handle property, large loss subrogation across the country. Big apartment fires, industrial fires, insurance company will pay the claim, hire me to go out to the scene, investigate the cause of the fire, and then over the next couple of years we'll subrogate. So now and then, probably about 10-15% of my subrogation practice is workers' compensation subrogation, which you're familiar with. So you're probably asking, how did I get involved in this and what am I doing in this? Well, when I travel and speak at the conferences, subrogation conferences around the country, 2 or 3 years ago, people started to, when the municipalities, and you've all read it in the newspaper, we'll talk about in a second, you know about the opioid epidemic, that the municipalities started to sue Big Pharma, and those cases there's 2,000 of them pending right now, and they're all consolidated in something called multi-district litigation in the Northern District, federal court in the Northern District of Ohio. So when I would go to these conferences and I would meet with some of the subro work comp lawyers, they would say, because they know I handle larger cases, why aren't the work comp carriers subrogating and getting into this litigation? So over the next year and a half, we started to look at this while monitoring what's going on in the multi-district litigation. And the long and short of it is that you can be, and you probably should be, if you're a work comp carrier, involved in and seeking recovery of everything you've paid for opioids and opioid treatment as far back as your records show. And we are putting together a group of insurers to join forces and to get into the multi-district litigation. Just recently, in the last 4 or 5 months, about 4 or 5 work comp carriers have joined the MDL, and we're about ready to join too. So this is a presentation. I'll be very quick, 10 minutes, show you a few slides so your antenna is up and you're aware that for those of you who work in work comp and are paying astronomical expenses for opioids and opioid treatment, and we'll talk about the difference in a second, there is a path for recovery. And we would be more than happy to talk to you about it at a later date. Okay, so everybody knows what the issue is. Very briefly, tens of thousands of people have died as of 2016. 11.5 people have misused opioids. 2.1 million people misuse opioids for the first time, and the cost to the public is $500 billion. That's important. It's important because the outcry of the public is being heard by the judges who are hearing and this, I want to say work comp subro cases. It's not really subrogation. Subrogation is when you sue the person who caused the injury. This is simply a lawsuit to recover the expenses. It's under the realm of subrogation, but it's not truly subrogation. A couple of key statistics here. The work comp industry has spent $3 billion a year on pain medication. $2 billion of that, 2/3, is for opioids. The next one is a key statistic. Of that $2 billion, 99% of those prescriptions were written for longer than 3 days. 3 days is the key because that's when the CDC determined that there should be no opioid prescriptions past 3 days. 0. So the gist of the lawsuit is that any opioid prescriptions you've paid for longer than 3 days, we can sue to get that money back. And this was despite the ownership and the board members knowing of the problems and knowing of their research that this drug should not be prescribed for long-term use. So what happens when the workers get on the opioids? Obviously, they need more and more because of the tolerance, additional TTD, additional time off of work, medical care, of course, unfortunately, now and then, death benefits, all of this which is paid by the work comp carrier. So the lawsuits began. There are about 2,000 of them, all of them in the multi-district litigation in Ohio. Most of those lawsuits are municipalities. Some of them are individuals, but most of them are municipalities. They've set up 3 different tracks. There were only 2 tracks until last year. They set up a third-party payor track just about 8-9 months ago for health insurance companies and work comp carriers. So they're expecting us to get into the litigation. The parties that are being sued there's about 15 different manufacturers. A couple of the big names are Purdue and Teva, Johnson & Johnson, Cephalon, and the distributors. We are not suing the pharmacies. We are not suing the pharmacies. The causes of action is called RICO, and the gist of it is it's deceptive and misrepresentation trade practices, that there was a marketing campaign just to mislead the doctors, to encourage them to continue to prescribe these opioids, and to get the work comp carriers and their formularies to approve these prescriptions. In other words, you guys have no choice but to pay these. So what did the manufacturers know? What's the gist of the lawsuit? They knew that the opioids had minimal effect. They knew that they were addictive. They knew that there are tolerances that build up, and more and greater doses would be needed. They knew about withdrawal. They knew about the addiction, and their plan was if they get addicted, that's fine. We can also prescribe drugs to help the addiction. So they make money on the front end. They make money on the back end. In the 1990s, before this epidemic started, opioids were very cautiously prescribed because the doctors knew or thought or believed that there was a potential for addiction. But through the deceptive marketing practices of the defendants, they were told, don't worry about it, do your job, prescribe and prescribe more, it will be fine, and that's your job. And of course, it got to the formularies of the work comp carriers, and hence the deceptive practices. I'm just going to show you a couple of 2 slides here. This comes from the complaint that's already been filed with the MDL. These are actual quotes for them from the complaint. Over half of Purdue's revenue stem from opioids. Oxycontin, the best-selling opioid for Purdue. Since 2009, national sales have fluctuated between 2.4 to 2.9, up 4-fold, despite their top executives pleading guilty to criminal charges for deceptive practices. So that didn't stop them. They just continued to do it. This is why the cases are starting to settle in the MDL. This is interesting. Each of the manufacturing defendants, again, this comes from the petition that's filed. Each of the manufacturer defendants' documents and other materials outlined below. By the way, this is a 365-count petition. This is it right here. It's about 120 pages, and this is just 3 or 4 counts or paragraphs from the petition. Each of the manufacturing defendant documents and other materials outlined below was to promote opioid sales and use so that the doctors would continue to prescribe them, patients would actively seek them, and insurers and health plan administrators would approve the drugs for inclusion and payment and reimbursement. So again, if there's not a pocket to pay for these, there would be no purpose for the deceptive trade practice. They knew that the insurance companies were going to be paying for these. So, if you're interested, here is what we're suing for. 2 categories. And this is not just our firm, but other lawyers who are handling work comp subro within the MDL. 2 types of category of damages. Number 1 is any prescription that you have paid for longer than 3 days, the patient was on it for longer than 3 days, that is an expense we should be able to recover for you. So what we're having our clients do, and we are here to help you do that. We have IT people, not within our firm, but that we're going to be using to help you do your searches and get the documents. We need you to go back as far as you can and get all the records you can that support the opioid prescriptions that you have paid for longer than 3 days. The second category of damages that we're suing for is anything related to treatment, whether it's inpatient, outpatient, therapy, other drugs to treat the addiction. All of that is recoverable in the lawsuit. So if this is something that you're interested in, call us. We'll be happy to meet with you. It sounds like an overwhelming task, but we can help you find the documents. And there's money sitting out there. Eventually, it's going to run out. Purdue and Teva, although they're multi-billion-dollar companies, these lawsuits, there's 2,000 right now, there'll be 4,000 next year. Not to mention the possibility of legislation coming down to possibly limit their exposure. So, work comp sub-row for opioids, it's available, and we'll be happy to help you with it. Any questions?
Rich,
Yeah.
I've got
Yep.
a question from the audience.
Okay.
The question is, what about the doctors who are prescribing? They wouldn't be taking the drugs if someone wasn't writing the scripts.
Right. Well, that's when the litigation first started, they sued the doctors. Now, as with most plaintiff lawyers, doctors are going to have limited funds and limited insurance policies to pay these. The doctors certainly could be responsible parties. But this lawsuit is about the deception from Big Pharma to the doctors, to convince the doctors that you should be prescribing this by giving them false information about addiction, by convincing them and showing them false data that more is better. So in a way, the doctors, the argument that we're making is the doctors are victims of the deceptive acts of the manufacturers.
Got another question from the audience.
Okay.
This one says, you are inviting insurers to the litigation. What about insurers with large deductibles or self-insured retention?
SIRs also, same thing. If you paid it, whether it's through an SIR, deductible, you're invited into the litigation. Same cause of action, same deception, everything, same damages. Okay. Well,
Any other questions for Rich?
Then let's get on to the real show.
Sorry.
There's one more.
One more question. How far back can they go?
That's interesting. It all depends on which state you're in, what the statute of limitations may be in that state, when the injury was, and so forth. So we're asking you to go back as far as practical. For example, if you have a new system, and a lot of people have new computer systems about 5 or 6 years ago, and it's easy for you to go back only 5 or 6 years, then that's fine. If you're capable going back 10 years, go back 10 years. We would like to present as much as possible. Then we see whether or not there's a statute of limitations for that particular state, to cut that off. So go back as far as you can.
Next question is, does this apply?
Wait, just to be clear though, but that doesn't mean it'll be recoverable, but to be safe, go back as far as you can.
Next question is, does this apply to group health insurers also?
Yes. In fact, the third-party payer track that I mentioned includes Blue Cross Blue Shield, group health entities. Oh, Mike? Oh, okay.
Sorry,
So the answer is yes.
I've got a couple more.
Sure.
What insurance agencies have joined these suits, if you can tell us?
I could tell you one that I am privy to. That would be West Bend. That's the only one I'm privy to mention. There are 4 or 5 others. And there are the big ones you're probably thinking, such as the Travelers, Liberty Mutual, those companies, I think that they're on the fence. Everybody was waiting for a work comp carrier to get into the ballgame. They recently got in, and I'm starting to get more and more phone calls from other attorneys representing carriers, and they're right on the verge of getting in too.
Next question is, where do you get the 3-day prescription limitation?
CDC. CDC. Now, the advantage of multi-district litigation, excuse me, I've got horrible allergies, is that we all get to share experts. So obviously at this point, since I'm not in the lawsuit, I'm not privy to what the liability experts are saying as far as the cutoff date. We expect it to be all the prescriptions are recoverable, but at a minimum the 3 days that the CDC recommended.
Does this apply to claimants who now reside in other states and fill in other states, even though their claim is a Missouri jurisdiction?
Yes. And in fact, most of them will not be Missouri. It's going to be more of a macro vision of this. So if you're, insurance company A, and you write work comp policies in 5 different states, we don't think it's going to be your bottom line numbers on what you paid. The state that it came from probably won't have much relevance when it comes to negotiating a settlement. If it's ever tried and we go through motions, possibly so, but I don't think that people from different states are going to be treated differently, other than the statute of limitations.
Next question. Show me the money. How long until the insurers would see the money?
I don't know. I don't know. Here's the issue, is whether or not the insurance companies and that third-party payer track are going to be treated differently and be put at the back of the train compared to the municipalities. That sometimes happens. So I would say in about 2 years, 1.5 to 2 years after filing, there should be some type of settlement.
Next question is, does this apply to mail order filled scripts as well?
If the insurance company is paying them, I wouldn't see why not. Now, keep in mind, we are not looking for individuals. We're not looking for individual people who had an injury to represent them. It's the insurance companies who we want to represent on behalf of everybody you paid for. Let's go with one more question because I think I'm taking time from the group. I don't want to do that.
I think that's all I have.
Okay.
I have one question. Is there a deadline for entering into the...
No. The deadline is that the money will go away. That's the only concern. Yep. Or bankruptcies. So I will leave cards. I'll also be here for about an hour. At the break, feel free to come up and ask more questions, and thank you for your time.
All right, for everybody who's maybe new, this is Jack. Jack was the subject of last year's seminar. Jack was young. Jack had a bit of a criminal problem. However, he was working as a pizza delivery guy, and he got injured, and he had a work comp case. And that work comp case did eventually settle. There were some issues. There were some concerns about marijuana use. Was Jack a drug dealer? Lots of things kind of came up in that one. But as we move forward, Jack found himself in jail after the work comp case. And, like some people do in jail, he found himself. He reformed. He made friends. And then, and I guess to back up a little bit, you'll notice Money Miles is on the stage today. Money represented Jack in his work comp case. And Turns out that Jack and Money maintain that relationship, and Money is actually Jack's personal attorney at this point. So
Keeping it real, Money. Right.
Jack realized what he wanted to do with his life, and he had a couple more years to serve, and he ended up hanging with people that had similar interests. And so he decided to go into a new business venture. Jack likes cars, always has. And so he decided to open up a shop. The friends he made in prison were the people that he hired. He ended up hiring a bunch of ex-cons. They work for him currently, and this is, I guess, a decent snapshot of his business. With ex-cons, you're going to have some issues, and like I said, Jack keeps in touch with his personal attorney, and turns out that he is having some issues right now, and in fact, I think he's getting ready to call in. As soon as Money can get her phone working.
Hey, I'm getting a call. Hey, it's Money.
Hey, it's Jack!
Whoa, Jack on the big screen. How are you? How's that shop coming?
Working for the weekend. No, really, it's great. You know, I got 5 techs working for me now, along with 2 staffers to help with the paperwork and accounting. You know, the smart people.
That's great. Congratulations. I'm glad you got everything worked out with the trademarks, background checks, your employee handbook, all that good stuff.
You know, I wanted to call and thank you just so much for helping me set up the business and helping me with the lease. Man, that stuff was so difficult, but I do really appreciate it.
Of course. Any issues with those felons you've hired? Has everyone been behaving there at all jacked up?
You know, it's funny you should bring that up. As I was leaving to run errands today, one of the customers got into it with one of my techs, Anthony Michael Hall. He was accusing him of stealing his gun case from a car he was working on. I don't know. I think those 2 might have a history.
Wait. Didn't I help Anthony on a plea for receiving stolen property some years ago? And doesn't he have a very ill-tempered brother with a long rap sheet?
Yeah, that's the same guy, and it's the same ill-tempered brother. Heck, you might even know the customer involved in this deal. Judd Nelson, he's some sort of private investigator.
Private eyes watching you. Oh yeah, I know that guy. Why is he hanging out at your shop anyway? Let's face it, Jack, you're not located in the best of neighborhoods, you know.
Well, you know, it's all I could afford, and we do good work. What can I say? Hey, you know, I'm where I need to be. I'm going to let you go, but I'll talk to you real soon, okay?
Hey, sounds good, Jack. You be safe out there. Take care. Hey, why do I feel like tacos?
Again, I'd like to welcome everybody today to Evans and Dixon's production of Breakfast Jack. Our players, Judd Nelson, as Judd Nelson, Anthony Michael Hall, Emilio Estevez, and there's Jack. I got to tell you, prison did a number on him. But he's all grown up, and he's ready to go. We got Elizabeth Shock Legal.
Tell them about my picture.
Yep. Elizabeth's been with the firm for a long time. And that was her first day. Yeah.
See what this place does for you?
We got Nancy Drew, our adjuster from last time around. She's back on the case. Then we got Lori the Ringer Ringwall. and believe it or not, That is a young Sean Roland I. Dolan.
Wait, can I interject here? We asked him why his hair was blonde. He said that's how he got his wife. So.
He said his wife's actually in the picture. She's kind of, she got an ear right there.
We cut her out.
She wanted to be cut out.
And Susan Money Miles in front of the Federal Reserve, just like it should be. Well, it looks like Jack made it back to the shop, and after a few errands, he's got a few more questions for Money.
Hey, Money, I'm back at the shop. When we talked last, I forgot to ask you, do I really need to carry a work comp policy?
Yes, we've been over this. Gosh.
Oh my God. Oh my God, that's gunfire. I think that's Emilio. And is that Judd Nelson on the ground? Where's Anthony at? My God, Susan, something bad happened. Something bad.
Jack, you need to call the police right now. I'm on my way over.
Police? Ambulance? More lawyers? I gotta go.
Jack! This damn kid.
You notice he wasn't running real fast.
Too damn old.
Well, later that night, Money called Jack just to check up on everything from the events of the day.
Hey, Jack, it's Money. Look, I hope you're recovering from all this. I just wanted to follow up and remind you to be sure to capture all the surveillance footage, pull your HR files, the handbook, get your witness names, any pictures you took, so we can give all that to your insurers. Right. As we discussed, in addition to the criminal investigation, I'm sure you will have a workers' compensation claim from Anthony, and there will also be a personal injury lawsuit from Judd because the shooting happened at your property. Yes, I know you weren't the shooter, but Judd will argue that your business practices set the stage for it. I know, just be calm, yes. I need you to compile everything I asked for so we can prepare your defense. You've been through this. Your documentation is important. Okay, good, all right. Hey, don't forget I'm auditioning for Star Search next week if you can't reach me for a bit. Toodles.
Well, ladies and gentlemen, at this time I'd like to introduce Lori Leschner. She's a member at Evans and Dixon.
Good morning.
Good morning.
So that's a hard act to follow, but I'm going to give it a whirl. So I'm here to talk about criminal acts on your property, some implications in workers' comp and premises liability. There's a few of you in the room that have probably seen this presentation once before, but hopefully there's a few new updates that you'll learn. So do you have reason to be concerned? You are either a business owner or a property owner, property manager. You have insureds that have businesses and properties, or you are self-insured. All of this applies to you. A crime just was committed on your property or your insured's property. The crime resulted in some injuries to either invitees, so people that came onto your property that were welcome onto the property, and or employees. Should you be concerned about the claims against your company, your insured, for a random crime? In our defense-oriented Missouri, of course you need to be concerned. Of course. So, frequency of assaults. Per OSHA, this is to me a startling statistics. Everybody goes to work thinking, I'm fine, I'm not going to get injured. Over 2 million people per year report being a victim of a workplace violence. At greater risk when you're an employee is responsible for money, works with dangerous or unstable groups, works in isolation, involves a service, works with alcohol. or works in dangerous times or in areas that have a high crime rate, so late at night, early in the morning, dangerous areas, dangerous neighborhoods. That's going to become important later on in my presentation. So potential claims that may be filed, depending on the details of the fact scenario. So obviously the typical lawyer answer, it depends. It always depends. But an employee could potentially file a workers' compensation claim, also could potentially file a civil suit. Usually it's one or the other, but in certain instances they can double dip. An invitee can also file a civil suit. So let's talk about the workers' compensation claims. In Missouri, you know, hopefully we all know this pretty much, but in Missouri, employees who are injured either in an in an accident, that is in the scope and course of their employment. That is where they can file a workers' compensation claim. Now, what is an accident? Under 287.120, the accident terminology is defined as injury or death of an employee caused by the unprovoked violence, that's important, or assault against the employee by any person. First question to ask is, what type of assault do we have here? So when you're evaluating a claim, when it comes in under workers' compensation, what type of assault do you have? There are three options under Missouri workers' compensation law. You got work-related, you have personal, and you have neutral. 2 out of the 3 are going to be compensable. 2 out of the 3. Work-related is going to be compensable. This is when the assault is related to and or arises out of the employee's work. Customer assaults an employee. That's a given. That's in their scope and course. Co-employee assaults an employee. Again, a given, but you still have to evaluate the motive. We'll get to that in a minute. But essentially, if there is no personal motive whatsoever, none whatsoever, it just has to do with work associated with the assault, and the assault occurred within the scope and course, it's work-related and it's compensable. Then you have neutral, good old Switzerland. Compensable, again. But this is a situation where we cannot figure out definitively what's the motive here. Is there a personal motive? It's a big question mark. We can't prove it. Therefore, it's going to be deemed neutral, and it's still going to be compensable. The only time it's not compensable is when it is personal and you can prove it, and you know it. This is committed in the course of private quarrels that are purely personal to the participants. Private quarrels. It's great terminology, right? If it is determined and can be proven that the assault arose out of a personal dispute, then it falls in this category. But it doesn't matter if the assault was unprovoked. I'm at work, I'm minding my own business, an ex-boyfriend comes in and decides that he wants to commit an assault. It doesn't matter if I am just sitting here minding my own business, did absolutely nothing. If there is a personal motive, a personal connection with the assailant, done. Not compensable, you're in the personal category. So, some examples of this, which are just astonishing to me. A gas station patron throws acid in an employee's face because he thought the employee had been kissing his wife. Doesn't matter if the motive was mistaken, it's still the personal motive, there's still a personal connection. Employee's boyfriend, who did not work with the employee, came into work and stabbed her and abducted her. These are scary scenarios, but it's real life, it's what happens. Another one, employee had been physically abused by her boyfriend outside of work. She was shot by her boyfriend while working. It doesn't matter if there's a prior history between these two of assaults or violence outside of the workplace. What matters is what happened within the workplace at the time of work within the scope and course. If there's any type of personal motive, personal connection, you want to look at the relationships between the two parties, or if there's multiple, and figure out, is there some kind of connection, some kind of relationship. If there is, more than likely you have a personal motive. Another thing to consider when evaluating these workers' compensation claims for assaults in the workplace is penalties that may be applied to the case. You can apply if you can prove that the employee failed to follow the employer's policies and procedures, thereby resulting in the assault. So you got two standards here. Prove that they failed to follow the policies and procedures, and it was that failure that then caused the assault. So did I not lock the door when I was supposed to, which allowed the assailant to come in and resulted in the assault? Would that door have stopped the assault from happening? If that's the case, you could apply some penalties, but, okay, I don't do workers' compensation, so let me just put that out there, but I'm told that the judges absolutely hate to apply penalties. Is that correct?
Absolutely.
Okay, so if they hate to apply penalties, and in compensation you have medical that's 60% of the value of the case, if penalties are applied on the medical, you're bound to go to trial. So yes, the claim's going to drag out for a bit and you're rolling the dice and going to trial, but ultimately, as we'll go through on the civil side of things, comp is much quicker and less expensive to go through than a civil case. So you may want to go ahead and find, if you can, oops, I can't prove that personal motive. You're in the neutral or you're in the work-related categories, and therefore it's going to be compensable. You have a comp claim. Hopefully that means it's keeping them out of the civil case. Civil claims arising from crime on the property. So litigation can arise from crimes on the property relating to any kind of crime, but primarily it's going to relate to violent crimes. This can be rape, kidnapping, murder, assault, whatever it may be. Crimes can be committed by a stranger, a third party known to the victim, an employee, the owner of the business. It can be anybody. Crime can also occur anywhere, at any time. It cannot be prevented, but deterrence is a key. So in Missouri, there's a general rule. Property owner does not have a duty to protect against criminal acts of third parties. Makes sense, right? I'm a business owner. I just have people coming in on my property. How am I responsible for Joe Schmo just deciding one day out of nowhere to come on my property and commit a crime? But with every great rule of law, there's exceptions. So prior to last summer, we had the standard that the Missouri Supreme Court basically set out in the case law when they had essentially adopted Section 344 of the Restatement Second. This recognized a duty on business owners to protect their invitees from those criminal acts. The duty arises out of circumstances in which there is a foreseeable likelihood, that is the key terminology, that particular acts or omissions will cause the harm. It is the particular acts or omissions of the business owner that then would that give rise to the actual foreseeability of the act or the harm happening. So you apply a test called the totality of the circumstances, and we'll look at that in a second, to see if the duty exists. Was it foreseeable? Was my business almost like a little beacon, like calling Batman or something, to my property, hey, come commit a crime here? The exact crime or injury doesn't need to be foreseeable. I didn't need to know that a shooting at Jack's property was going to happen. I just needed to know that it was foreseeable that some kind of crime could probably occur at this property because of certain circumstances. So foreseeability is based on a whole list of items. Prior crimes involving employees or parties at issue. That's pretty self-explanatory, but prior violent crime on the property. What happens in these cases, this is why they get so expensive. I get the case in. I need to go to the police department where the property is, ask them for what's called a CAD log, a calls for service log. I get that, then I evaluate and figure out, okay, which ones resulted in a police report. Then I have to evaluate that, make the request, which is always so much fun. You have to wait forever, get the request back where I'm getting all the police reports, typically within about a 5-year period prior to the incident. And I'm looking at those police reports, figuring out, weeding out which ones are violent crimes on the property, which is a whole various categories of crimes. But I have to figure out which ones actually happen on the property. You could have calls from that address, but it doesn't mean that the incident actually occurred on that property. So then I'm taking that data and I'm crunching the numbers and I'm figuring out how many violent crimes per year do you have on that property? What type of violent crimes do you have on that property? At what ratio do we have the rapes? Do we have murders? What do we have going on at this property? That is going to be key for your calculation of foreseeability, and then I can hopefully work with the expert and feed them that information. Property owner management knowledge of those prior crimes. Did we have complaints? Do we have reports? Do we have incident reports? What did we know about this? Violent crime rate at the property, I just talked about that, but then crime rate at similar surrounding properties. So that process I just described, we do it again. We look at a 5-10 mile radius right around the property for similarly situated businesses and try to figure out, is my rate lower than a lot of these other businesses? If it is, we're doing pretty good. If it's not, we got a problem. Security measures at the property. Do we have guards? Are we supposed to have guards? Do we have locks? Are those locks working? Are they utilized? Lighting. Is the parking garages, are those well lit? Are they a cloak of darkness that everybody can come in and feel safe in committing a crime? Landscaping, sounds a little weird, right? But are those bushes overgrown? Is everything overgrown where you can hide behind and perpetrators are saying, oh, well, that's probably a good place I can go hide? Surveillance, do we have it? Does it work? Does it actually record? Alarms, do those work? So maintenance of the security measures, just because you have them doesn't mean necessarily you're good to go. You have to maintain them, they need to be working. Prior complaints by employees and customers. What's the nature of your business? Are you a bar that's open until 3 a.m. in a bad neighborhood? You probably have some hurdles to overcome in these cases. Prior knowledge of violent propensities of the actual assailant. Is that person known to us? Have they been there before? Do we know that they have a rap sheet? So this summer, Governor Parsons signed a bill, 608. This went into effect on August 28, 2018. It's now called the Business Premises Safety Act. It creates a clear-cut law that creates this duty that the Missouri Supreme Court, but it also attempts to limit and define that duty. They're trying, but we don't necessarily have case law yet that's really giving us good guidance on the interpretation of this. But if you look at it, I'm not going to read it out loud, but if you see, number one, it still creates what I interpret to be still a foreseeability test. Do we know, should have known that this was going to happen? But then you have the extra prong of and. Was sufficient time existent to prevent such crime? If this happens within an instant, how did I know? How could I have prevented it? So you have to meet both prongs. It also creates some affirmative defenses that we can elicit if the scenario is correct. So no liability if the business has implemented reasonable security measures. What does that mean? I don't know. We still don't know. That still needs to be interpreted. They try to define it within the statute, but it's not quite, it really doesn't do much for us. So what's a reasonable security measure? If I'm a bar open till 3 a.m., what do I need to have in place to say that I had reasonable security measures and this case could just be taken out by a motion for summary judgment? When the claimant was a trespasser under the influence of alcohol or controlled substance or was committing or attempting to commit a felony. Key, Trespasser. Number one, they weren't invited on the property, they came on anyway. And number two, they were either under the influence or they were about to commit a crime. Typically, if you have a violent crime happening on the property, you're gonna meet this second standard anyway. I mean, I guess if it's a misdemeanor, we got a problem, but probably going to be a felony. The criminal act or harmful act occurred while the business was closed to the public. Sometimes that happens. People go into a parking lot and commit a crime. The business is closed. There's nothing that the business could have done. Other considerations are comparative fault for provocation, failure to follow policies and procedures. So if the victim was your employee and files a civil suit but didn't follow the policies and procedures. Is it a targeted crime? Did that assailant want to come get me no matter where I am? It doesn't matter from here, my home, my office, doesn't matter. It's a targeted crime. They were coming for me. Stay. You may want to issue a stay on the case while the underlying criminal case is actually pending and until it's adjudicated. That way we can bring into our case proof that that assailant is the person that committed the crime. Just because they've been charged doesn't mean that it's admissible that I get to bring that in. I need the actual conviction to be able to say that is the person that did it, here's the link, here's why they did it, here's why it's a targeted crime, whatever I may need to bring into the case. So you may want to stay discovery until that's figured out. You also may have liens, workers' compensation liens, medical liens. There are things to consider. Keys to a successful defense is maintenance. Again, we kind of talked about that. I had a case where it was multiple apartment buildings making up a complex. Each building had locks on doors in order to access the building itself. It was a rape case. They were claiming that we did not provide sufficient security. Well, yes, we had locks in every door, but tenants did not like those locks. They had to go down and let their friends in. They had to carry groceries and try to use the keys to get in. So what do? They broke the locks. They stuffed things in the locks. Our management couldn't keep up with the broken locks. Well, that created a problem. Even though it seems like smoke and mirrors, and the evidence was the door was locked at the time the incident happened, that doesn't matter. Does it mean that it's foreseeable that a crime could be occurring? Yes. Policies and procedures for security. Do we have those in place? What are they? Are they sufficient? Then do we train the employees on those policies and procedures? Just because we have those policies and procedures, if our employees don't know about them or don't follow them, we got, again, another hurdle to overcome. Documentation, documentation, documentation. I can't stress that enough. Every case that I've had, even if it's a slip and fall, but especially these cases, comes down to documentation. Most likely, I am trying to prove a negative. I never knew that there was violent crime on the property. I never got a call. I didn't have a work order on those locks. I never got this complaint. Well, how do I prove that? Well, we take meticulous, I can't even speak this morning, meticulous records, and we keep those, and therefore you see all the records that I have. I'm detailing every complaint that I've ever received. If it's not in there, it didn't happen. Well, if I'm getting police reports of incidents and it says spoke to manager, manager says da 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 da, and then I don't have an incident report or even a work order for the property damage or something coming from that, oops. Now I don't have detailed documentation to be able to prove that negative that my client is saying happened. So it's written documentation, photographs, videos. Deterrence is vital. I'm not going to go through this, but be proactive, not reactive. All employees should be familiar with the policies and procedures. Can't just rely on your reports and complaints by customers and tenants. Your insured should have employees walking around their property making sure that they're checking for unsafe hazardous conditions, that's trip and fall hazards, whatever, but also, do we have bushes overgrown? Is that light bulb out? Do we need to change that? Is that lock broken? Be sure to implement a checklist to complete during property inspections. That way it's keeping them on task and knowing exactly what they need to check. Most, if not all, cases rest on the documentation, which is what I was just talking about, but it paints a picture of what is happening at the property, but also what is not happening. It's proving that negative. Good records typically are indicative of a good maintenance and management program. Another thing I like to talk to my clients about and insureds is build relationship with that local law enforcement. They can be your eyes and ears. You're not on the property all the time, or your insureds aren't. So that law enforcement may know that you're coming in on Monday morning, and they may stop by and say, hey, by the way, we got a couple calls to the property, and then that way, that property manager, that owner, that whoever your insured is getting notification of what's going on at the property. Or, by the way, I hear rumblings, tenant so-and-so is arguing with the other tenant, and I got a call for a noise disruption. Well, then you know there's an underlying issue, and you can start responding to try to prevent anything from escalating. Response to notice of an assault. Management must make a quick and thoughtful response. Notice can come from any source. So just take it for what it is. If you get notice from anybody, start investigating, start figuring it out. The person that receives the first notice of incident should immediately report it to their supervisor, and then hopefully notify their insurer. Let them know so that they can get on board and start figuring out and telling the insured, what do you need, what kind of documentation do you need to secure, what kind of investigation do we need to start. Possibly, hopefully, this may be gratuitous, but then the insurer can notify us, we can get out to the site and or be in touch with the management and start guiding them through the process of what documentation do they need to preserve, what do they need to collect, also may need to work with the police. But then you have another category of these plaintiff's attorneys, these claimants' attorneys, getting out to the property. That rape case that I was just talking about, the plaintiff attorney had been out to the property immediately, taking videos of the broken locks, taking photographs, interviewing all the tenants, taking video statements. I had no clue. I was way behind the 8 ball when we got into that case and trying to play catch up, let alone I didn't know about any of that stuff until way down the line because he doesn't have to give it to me right away. So get us involved if you get one of these nasty, nasty situations so that we can be on top of things. Incident reports, again, I'm not going to go through all this, but they need to be very detailed, very, very detailed, and provide a lot of information that people don't necessarily think about. They get a little statement, they have the person sign and date it, but it doesn't really tell me timeline type of information that somebody may not remember down the line. Photographs and videos of the scene are important, and then maintaining those documents. So I appreciate your time. I hope you all enjoy the rest of the show. If you have any questions, go ahead and text Maria. I appreciate it.
All right, just so we have a timeline, where are we in our story? We are about 2 weeks later after the incident. Judd Nelson got shot. Judd Nelson hired Roland I. Dolan as his attorney.
It's money, honey.
Hey, Money, it's Roland I. Dolan calling you on Judd Nelson versus It's Jacked Up.
Hey, Roland. Sorry, hold on one second. Can you hold on? I need to set the office VCR. L.A.L.C coming on. Hold up. Okay, wait. Okay, I'm back. What's up? By the way, you know I've always wanted to ask you, what does the I in your name stand for?
It's in the, as in Roland in the Dolan. My parents clearly knew I was going to be successful. So anyway, I spoke to Jack, the owner of this crackpot place, and you claim to be a place of business. And it's a place of torture, if you ask me. Anyway, Jack told me to give you a call.
Wait, what? Why are you calling my clients?
Take a chill pill, money. I didn't talk to him long. He told me just to go through you.
Oh, yeah, he better.
Well, listen, I had no clue he had counsel for this case already. Can't say I'm happy about it. It is much easier to get money from him than it is from you. So, you know I filed suit, but this case needs to get resolved, like, today. Mm-hmm. And my guy, Judd, who is an upstanding rule-following private investigator.
A rule-following PI, that's funny.
Well, easy. He was at your shop just minding his business and waiting to get his car fixed. One of your ex-con employees, Anthony Michael Hall, tries to steal a bag from him. I'm sorry, tries to steal a bag from Judd.
Sure.
And in a very calm demeanor, Judd confronts Anthony about the bag. Of course, Anthony goes into his gang mentality and calls henchman brother Emilio Estevez and to do his dirty work. Judd ends up with a bolt in his leg, which required surgery to repair the broken bone. Bills and other damages are going to be so high, they're going to be astronomical. And don't get me started on potential for punitives.
Okay, so that's the version your guy Magnum PI told you, but I'm sure Matlock will find out something else before trial.
Yeah, your Matlock was going to find that this business is riddled with convict employees in a horrible crime-ridden neighborhood and without any type of security. It's a recipe for disaster with foreseeability for days.
Look, just because a business employs a felon, that doesn't mean there's automatic liability for any incident that may happen on site. Besides, everybody needs and deserves a second chance. It's the facts of life, Roland.
You want to know the facts of life, money? It's easy. I want the limits, and I hear it's $1 million.
It's not what you want, it's what you can prove, duh.
The heat is on, and Jack is now in the danger zone. Tell your guy he's about to pay up because I am hungry like a wolf.
What?
Innocent patron shot, broken leg, surgery, time off work, pain and suffering. You're going to make a grown man cry.
You're boring me.
Remember, I get to say the following to a jury. My law-abiding client was brutally shot while simply waiting for his car to be repaired. You're playing with fire here, money. This should be $1 million. $1 million and done.
Hey,
my
Roland.
guy would.
Roland. Hey,
What?
knock knock.
Really, money?
Yeah, knock knock. Trust me, you want to answer this door.
All right, I'll play. Who's there?
867.
867 who?
867-5309, Lori. Look, that's Lori Ringwald's number. She's at E&D, and she'll be defense counsel on this. You need to call her about this premature demand you're trying to peddle off on me.
Lori Ringwald at Evans and Dixon?
Yeah, you know that actress Molly Ringwald? That's her sister. So anyway, call her. She works hard for the money, so you better treat her right.
All right, I'll give her a call now.
All right, bye.
This is Laurie, the ringer Ringwald.
Lori, this is Roland. I represent Judd Nelson. Heard you're going to be defending this lawsuit.
Well, if it isn't rolling in the Dolan. I'm so excited to have you on this one. I just received the file. I'm still reviewing it.
Don't bother. I'll just tell you what you need to know.
This should be good. Give me your best shot, Roland.
Shot? Exactly. Innocent man gets shot. It's worth your limits. He's still treating and the bills are already high. The potential for excess exposure and with an award of punitive damages is, well, it's a given. Just pay the limits now and send me a release.
Easy does it, Roland. You really think I'm just going to take your word for it? Why don't you cool your jets, Top Gun? Give me some time to work up this case. I'll get back to you.
Let's go ahead and check in on the work comp side of things. Jack's attorney is checking in with the work comp adjuster.
Hello? Is it me you're looking for?
Hey, Nancy, it's Money Miles. It's been a while. How are you?
Working 9 to 5. I'm good. How are you?
Good. You know, I've been working on my new taglines as usual. Tell me what you think while I got you on the phone, okay? In a crash, get that cash. You like that one? What about it don't mean a thing if it ain't got your ching?
That's it, Money. Go with it. Go with it.
All right.
So, what's really going on?
Okay, so my client Jack, you might remember him from last year. He went to prison, he got his life together after that, and now he opened up this car repair shop.
Wait, Jack, the pizza guy?
Well, yeah, that pizza guy, but now he's the owner of It's All Jacked Up.
Gotcha. Really clever name for a shop. It's never boring with you, Money.
Hey, you know I try to keep it fresh. So anyway, Jack had his employee get hurt in a scuffle, which then escalated into a shooting of a customer, but it wasn't the employee that shot the customer, so don't worry about that. But anyway, there's an issue as Jack employs some felons on the premises. I mean, really, it's just another day in Moneyville. But I wanted to call and give you the heads up as to what was going on.
Ugh, you dropped a bomb on me here, girl. I'm not ready for another ride on Jack's crazy train.
Hey, no one ever is. I was also calling to see if Jack had work comp coverage when all this happened a couple weeks ago.
Let me look. Yep, there was coverage, but I'm not going to tell you yay or nay on the compensability until I get more information. I need a statement from him, I need a police report, any videos, you know the scoop.
Of course, we're getting all that together for you.
Okay, thanks for the heads up. I'll get with counsel.
Thanks. You know it's these bad boys that keep us in business, right?
You know it. I'll call my legal eagle defense counsel now.
All right, thanks.
Hello, Elizabeth Shock Legal.
Hi, Miss Shock Legal. It's Nancy Drew.
No nonsense, Nancy Drew. My favorite client, outside of everyone else in this room. What's going on?
Calling on a new case. A little ditty about Jack and Diane, but no Diane.
Okay, hold on 1 second. Let me shut my door. Okay, I think we're alone now. What's up?
Remember Jack, the pizza guy from a couple of years ago?
Jack? That stoner dude, Jack? What now?
Well, Jack owns an auto repair shop, and it seems an employee was assaulted by a customer and allegedly hurt his back.
Okay, what's our hero's name here?
Well, his name is Anthony Michael Hall. But we're still holding out for a hero, because this one is definitely not it. The whole thing escalated, and the employee's brother came up to the shop and fired a gun at the customer.
Well, Nance, you know you got to fight for the right to party. Well, Miss Drew, given your keen investigative skills, what have you found out so far?
I took Anthony Michael's recorded statement. I got some video from the shop that supposedly shows the fight. My IT department can't seem to get it to play, though.
That's odd. Can you email it to me and I'll take a look at it?
Yes, I'll do it right now.
Okay, what else did you learn from taking his recorded statement?
Well, he thinks he's pretty darn funny, and he smokes.
Like smokes Marlboro Lights or some of Jack's funny cigarettes?
Probably both.
So he thinks he's funny, he smokes. So he's a joker, a smoker, and a midnight toker?
Girl, you know it's true.
So has he had any medical treatment so far?
Yes, he went on his own before Jack reported the incident to us. He's had an MRI, and apparently surgery is being recommended. I think we should get a second opinion from Dr. Coyle.
All right. Did we authorize any of that initial treatment?
No.
Okay. I'm on board with Dr. Coyle. If it's compensable, we'll want to take control over the medical, obviously. But first, though, do we know who started the fight, Nancy?
According to Anthony Michael, it was the customer.
All right. And is there any reason to believe that Anthony Michael Hall knew or had a personal issue with the customer?
He says he didn't.
All right. Well, let's make sure on this. Let's take a look at that video. And you know that assault cases in Missouri can hinge on who started the fight as well as the reason behind it. So I'm going to pull up the video now. But first, I'm going to tell our audience about unprovoked violence or assault. Okay. So Laurie touched on this, and I just wanted to go over it at this point in the presentation. Unprovoked violence or assault under 287.120.1 in relevant part is that, you know, an accident shall include injury or death caused by the unprovoked violence or assault against the employee by any person. Unprovoked, as Laurie pointed out, is the important word here, and we call this the aggressor defense. So if we're defending a case and the employee was the aggressor, meaning he started it, he or she started it, we're going to defend against the compensability on that. The other important part is whether that job-related assault stems from a personal disagreement. We have to have one of those two, work-relatedness or neutral fights. So in this case, I think Jack mentioned that there might be some relationship between the employee and the customer, but for our purposes and Nancy Drew's keen investigative skills, there is nothing for us to believe that anything was personal in nature. So let's now see if our employee was the aggressor. Okay, Nancy, I'm looking at the video right now. All right, there's the employee, Anthony Michael Hall. Customer. Because we always have that kind of video, right? All right, Nancy, I just reviewed the video. Clearly, Anthony Michael Hall was not the aggressor. I would characterize this as an unprovoked assault. We know there was nothing personal between them, so I think it's going to be ours. Now, there's a third party involved, the customer, that caused the injury, so there is subrogation potential on this if that customer has any assets, which I'm going to highly doubt, but I just want to point that out for you.
Okay. I'll note the file, and if we uncover anything, I'll have your top-notch subrogation attorneys at Evans and Dixon pursue it.
Perfect, perfect. Okay, so let's get him into coil.
Sounds great.
Forgive my singing. Abra, abracadabra. He's seeing coil in 30 minutes. And Nancy, you remember, you can call me anytime.
I hate myself for loving you.
We hope everybody's enjoying the production so far. Our next guest is a surgeon who has been practicing in St. Louis for about 20 years. He attended medical school at the University of Virginia. Currently, he is in private practice at St. Luke's Hospital and is on staff at Barnes West and Mercy. Let's give a warm welcome to Dr. James Coyle. And before Dr. Coyle gets started, he is welcoming questions, so if anybody's got a question, we don't need to text it in. If you want to raise your hand or something while he's going along, I'd be happy to come over to you and you can direct your question directly to Dr. Coyle. Dr. Coyle?
Thanks. Can you hear me? Okay. Before I see Mr. Hall, I'm going to give you a crash course in spine surgery. So when I started to put this together, called it Spine Surgery 101, and I realized I had enough material for 2 semesters. So I didn't want to do this to you. This is more what I had in mind. So here goes, and I hope it's not this. Okay, so we're going to very briefly cover the basics. If you want to know anything about anatomy, it's all right here in this slide. But we'll go a little deeper into anatomy here. In my office, I have these 2 models, and I use those to remind me what I'm doing every day. The spine is 3-dimensional. We have to look at it 3-dimensionally and operate on it in 3 dimensions. So this is the lumbar spine here, low back, lumbar spine. If you look at the spine from the side, there are 3 areas we're concerned about. One is the cervical spine, or the neck, and that is 7 vertebrae. Now, a vertebrae is an individual bone. It's separated by the one above and below by a disc in between, and there are joints in the back. So the neck, where cervical spine has 7 vertebrae. The thoracic spine, which is the mid-back, has 12 vertebrae, and the lumbar spine has 5 vertebrae. We call them, for example, L1 through L5. Spinal cord comes down the middle and ends at the junction of the thoracic and the lumbar spine. The nerves in the neck go down the arms, the nerves in the low back go down the legs. Sort of a generalization, but that's basically what it is. If you look at the lumbar spine, this is L4. It's the nerve that comes out between L4 and L5. This is L5 nerve that comes out between L5 and S1. And this little nerve you see here is S1. That goes past this disc and comes out in the sacrum. Those 3 nerves combine and become the sciatic nerve. So remember this. If you have sciatica, you have something going on with either L4, L5, or S1, or some combination of all of those. So that's the end of spine anatomy. This is a little bit of a close-up of what happens at an individual disc space. You're looking at this from the side, you're looking at this one top down. Now this is the disc in between the 2 vertebrae. There's an opening on the left and an opening on the right, and the nerves come out like branches on a tree. Now we're in the lumbar spine here, so you don't have spinal cord. You just have a sac called the dural sac with the nerves in it. Now if a disc herniates out the back and it's on the side, it will hit the nerve coming out on the side. If it herniates in the middle of the canal, it'll hit the nerve going down the spinal canal. So terminology, I know that we put a lot of terms in our reports, and I could spend the whole talk on this, but I picked the terms that annoy me the most when people mangle them in depositions and things. And I have a couple of exceptions to that. This one, you'll say fracture. Everybody knows what a fracture is, but is that really true? Well, I'll tell you a story. When I was a resident, I had a woman who broke her hip. And so the family came in and I said, Grandma has a hip fracture. And they turned to each other and said, well, thank God it's not broken. So really, a fracture is a break is a break. A fracture isn't a little break or an almost break, it's a broken bone. Now this picture is a CT scan. It's called a computerized tomography. And the beauty of that is you can look at things in 3 different planes. You can look sideways, you can look up the canal, which is what you're seeing here. You're standing at the patient's feet, or you can look front to back. But these are the 2 most common planes we look at a CT in. And if you look up here, you'll see a fracture. There are a couple of things you'll notice. The top of this is shattered, it's collapsed down, it's angled here, and there's a piece of bone that went back in the spinal canal, and there are nerves back there. If you look at this view, you'll see that piece of bone. It's compressing nerves. So this slide demonstrates pretty much everything we operate on. There are some exceptions, but as a rule, everything we operate on is demonstrated. This picture looks like this patient is sitting or standing, but this is really taken when somebody's in a long tube, and so they're lying down. If this patient were to stand up, their back would collapse because it's unstable at this level. That's the first problem. There's a problem with the stability here. Second thing is there's bone in the canal, so this person has some kind of nerve injury or deficit or damage. And the third thing is it's angled and it's out of alignment. So every case that we operate on generally involves fixing some combination of nerve compression, instability, and malalignment.
Dr. Crow?
Yes.
Can you, and you may have said it, and I apologize, what level was that?
That's
Where the
L1.
fracture is?
That's L1. Okay. So the sacrum's down here. There's L5, L4, L3, L2, L1. That's right at the junction of the spinal cord. The spinal cord ends in this area, and it may end down here, and it may end up here. And to know that, you'd need an MRI. But we'll see some more of that later on. So this is a fracture. So if you hear the word fracture, somebody's got a broken bone. Now these 3 words are my favorite words to see mangled up. And I love to hear people in depositions mispronounce them. We'll take them one at a time. Spondylosis. The accent is on losis here, spondylosis. And we'll take a look at that. That comes from the Greek, spondylo, which means vertebrae, and osis, which means a condition. Spondylosis is a condition of vertebrae. Psychosis is a condition of your mind. They're all kind of osises in medicine. You learn that in your first year. But spondylosis is basically arthritis in the spine. It's bone spurs, or otherwise known as osteophytes. It's degenerative disc disease. Here's a little bone spur here. This is the facet joint in the back. Look at the one above. It's nice and smooth. This one's all sort of rat-eaten and bone spurs all around. So that's what spondylosis is. Remember that one. That's the simplest one. Second term is spondylolysis, and the accent is on lysis here, spondylolysis. And the lysis part of it means a dissolution in the bone. It's a breaking down of the structure. We're looking again from the side here, and you can see this. You have a disc in the front. You have a joint that connects with the level above here. It's called a superior facet. You have a joint down here that connects with the level below in the back, inferior facet. There's an area in the middle called the pars, and that has a crack in it or a fracture in it. Some people are born with this. Some people get this when they're in gymnastics in kindergarten or in high school, but it's basically a crack in the bone. It's not like an average fracture. It is broken, but it's something that we don't know when it happened. Sometimes you'll see it by itself. Sometimes you'll see it with other conditions. But it's a fracture of the pars. So a pars fracture is a spondylolysis. So now we know what spondylosis is. We know what spondylolysis is. Here comes the granddaddy of all these words. Can anybody say this? You can say it out loud or say it to yourself. Spondylolisthesis. Spondylolisthesis. Say it 3 times and you'll probably forget it by the time you leave. So anyway, that's spondylo, standing for the vertebrae, and a listhesis is a slipping forward. And that's what we're looking at here. This is L4, this is L5. You can see that it's translated. There's a step here on this CAT scan. Now this poor, unfortunate person has a spondylosis here, and they have spondylolisthesis here. We don't know if they have spondylolysis back here because my pen is in the way. But certain conditions with spondylolisthesis have spondylolysis back here, and that is called an isthmic spondylolisthesis. If you get away from here with this word, you've accomplished my course objective. So spondylosis, spondylolysis, and spondylolisthesis. Next word, arthrodesis. That comes from arthro, from the Greek meaning a joint. It's the basis in arthropod and a number of terms, and desis, which means to bind or fuse. So to fuse a joint is to do an arthrodesis. There's a saying in medicine, you can't have arthritis if you don't have an arth. And that's the reason why we fuse joints sometimes. We also fuse for instability. So this guy's sitting here and his doctor says, have you ever considered a spinal fusion? He's thinking of a nuclear explosion. And people look at it that way. Well, why would you fuse somebody? Why would you fuse a joint? For several reasons. One is if it's unstable. That's the most important reason. And a fracture is a good example. If you have to fix it, you've got to address the instability. Sometimes we fuse because it's painful. And sometimes we fuse because it's going to become unstable when we decompress it and take the pressure off of nerves. So that's arthrodesis. Well, how do we do that? The way we do that is we treat the body section that we're going to fuse like it's not a joint, but it's the 2 ends of a fractured bone. And what we do is we take off some of the cortical bone, which is the outer shell of bone, around each of the areas we want to fuse, and then we graft it with other bone. We put the bone around it in as many places as we can, sometimes in the back, sometimes in the front, sometimes in both places. I think this is something that anything worth doing is worth overdoing sort of situation. You have got to get a solid fusion. And I think one of the biggest problems with failed spine surgery is people are not critical enough about assessing fusions. And I'll talk about that a little bit. Where do we get the bone graft from? There are a number of sources. Allogenic bone graft, or allograft, is donor bone. It's basically cadaver bone that's tested, and there are different ways you can get that. You can get what's called freeze-dried cadaver bone. You can get fresh frozen cadaver bone, which is thawed out and is actually better to use. The second type is autogenous graft or autograft. That's another word you should practice, autogenous. I've heard that mangled many times. But that is the patient's own bone, and that's donor bone. So we take that from the pelvis, Some people say we take it from the hip. We don't take it from the hip because then you have a hip problem. In some countries in Asia, they actually use people's fibulas, and you can end up with a limp as well as back pain if you do that. So we don't tend to do that. If I need structural bone, that's bone to support the column, I will use allograft. If I can possibly use autograft, I use it. If the patient has poor quality bone, or in doing a multi-level fusion, I might use autograft and supplement it with allograft. So allograft is the donor bone, autograft is the patient's own bone. This is living bone. It's much more likely to give you a successful fusion. The other thing in terms of bone grafting is there are multiple synthetic materials with, there's something called demineralized bone matrix. There are all sorts of products that are thrown by us by salespeople. I'm what I call the surgical equivalent of an earth mother. I like using autograft whenever I can. The next thing we do when we graft the area we're going to fuse is we hold it together with instrumentation. When I started my spine fellowship and I was interviewing, one of the professors asked how many different companies made spine instrumentation. And this was quite a few years ago, and there were on the order of 50 companies making different instrumentation. At this point, it's hundreds of companies. And you can see that they're all different designs, but they all look kind of similar. Well, they all have, they're almost like Apple phone attachments. You know, every new model has a new attachment, and they're not interchangeable. It's a real problem if you're doing redo surgery and you're trying to take something out that was put in 15 or 20 years ago. So you can't believe the number of hexagonal and star screwdrivers and wrenches and things. One of my worst nightmares is getting in there in surgery and trying to take something out and not having the screwdrivers or instruments to get it out. This is just a sample of many, many screws that are used to stabilize the spine. The other thing we use is plates. These are 3 cervical plates. This is for a 1-level fusion. This is for a 2-level fusion, a 3-level fusion. We can plate the cervical spine and the lumbar spine. This is on to terminology against spinal stenosis. There is all manners of stenosis in medicine. You've heard of coronary artery stenosis or blockage, carotid stenosis, which causes strokes. Stenosis in the spine is narrowing of the spinal canal going up and down, or narrowing of the foramen where the nerves come out on the side. This is a side view or a sagittal MRI, and you can see here there's mild stenosis here. This is the canal full of nerves. Down here, there is severe stenosis. Does anybody know what else is going on right here? You see the step? You say the word? Spondylolisthesis. So it's causing spinal stenosis. So the way you treat this is with a laminectomy, and if it's unstable, you fuse it. This is a cross-section looking straight up the spine of that same MRI you just saw. This is a level where the spine is not stenotic, and this is the area for the nerves you can see in here. If we look at the one on the left, this is severely stenotic. It should be at least as big as this. But these joints in the back are arthritic, they're enlarged, which means they're hypertrophic, and they're compressing the nerves. I'm going to go back to the other slide and say, think of this almost like a garden hose being crimped at multiple locations. Here it's severely crimped, and this is what the cross-section looks like where it's severely crimped. So that's spinal stenosis. And spinal stenosis can be caused by a combination of arthritis, degenerative problems, congenital problems, which means you're born with a narrow canal, or disc herniations, or a combination of a number of things. Anything that narrows the canal is spinal stenosis. Scoliosis. Everybody's heard of scoliosis. It's simply a curvature of the spine, and there are different kinds. There's adolescent scoliosis, there's degenerative scoliosis. This is an example of degenerative scoliosis. This is a plain X-ray looking front to back. We call this an AP, or anterior-posterior X-ray. There's your pelvis. So we're looking at the lumbar spine, and the curve goes like this. Curve in the upper spine goes in the opposite direction. And a lot of times these people are well balanced. If you see them walking down the street, you'd never know they had it. The problem with scoliosis is that the thoracic spine or the mid-spine is protected by the rib cages, so that curve does not progress as much as the low back curve. And as people get older, they tend to get more of a curve down here, and it's not compensated up above, and then it's more obvious. The area for treatment of scoliosis is done by either pediatric spine surgeons in adolescents or deformity surgeons. It tends to be a specialty area. I trained with the president of the Scoliosis Research Society as one of my professors, but I do very little scoliosis. I certainly don't do the long constructs because it's a specialty area, and St. Louis happens to be one of the best areas in the world for scoliosis surgery. Radiculopathy, everybody's heard that term. It comes from the Latin root radicula for root, and the Greek pathology, which is basically any kind of pathology, and it precisely means a diseased condition of spinal roots. What I find is that it's not so much disease that causes radiculopathy, it's nerve root compression or nerve root irritation. Those are the two things we see most commonly. And the most common radiculopathy we see is sciatica. Sciatica is caused by compression of L4, L5, or S1 nerve roots, or any combination of all three. And that's one of the things we need to figure out when we see patients. These patients come in and they say, my hip hurts. What they really mean is their butt hurts. And the problem we have is they tell their family doctors their hip hurts, and so they get a hip x-ray. But when we see them, they have pain in this distribution. As that pain goes down to the foot, we can actually tell which nerve it's coming from. Up here, it's nonspecific. So that's what radiculopathy is. Cervicalgia. Cervicalgia is basically neck pain, pure and simple, and that can be caused by a number of things. It can be caused by a cervical strain. It can be caused by arthritis. It can be caused by tension headaches. It can be caused by disc herniations, but cervicalgia is neck pain. And it can be associated with cervical radiculopathy, which is pain and numbness and tingling radiating down the arms. Remember, the nerves in the neck go to the arms. So a disc herniation. I put this up here not because people don't know the term disc herniation, but because there's so many ways to describe it. HNP means herniated nucleus pulposus, and that refers to the inner portion of the disc, the nucleus being herniated out through the annulus. And if it herniates out through the annulus, it can compress the nerves going down to the legs. And this is a L5-S1 herniation. You can see it's on an MRI. You can see it's compressing. We're standing at the feet here, looking at it here. So this would be the right side. And we know that the S1 nerve root goes past here, and that's part of the sciatic nerve. So this patient's going to have right-sided sciatica due to a L5-S1 disc herniation. Now, these discs can be called HNP, disc extrusion, protrusion, prolapse, bulge. There are all sorts of names. And the important thing to note is there's no standardized way of saying what it is. People call it what it is. I've been asked in depositions, doctor, is this a bulge or a herniation? And my answer typically is it depends on whether you're a claimant's attorney or a defense attorney.
It's a bulge. It's not a herniation.
Pardon?
It's a bulge, not a herniation.
That's right, it's a bulge, until proven otherwise. Okay, spinal imaging. This is going to be a quick walk through history. We can't do anything without imaging the spine. I say spine surgery ideally is like going to the Holiday Inn. There's no surprise when you get in there. And I'm going to talk about this from a historical standpoint. These are some of the images that we get: X-rays, myelograms, CT scans, CT myelograms, and MRIs. The one thing we cannot do is image like cardiologists can. We don't have a motion picture MRI. We have pictures of what the spine looks like when somebody is lying down. And that's like taking pictures of two tires. One has 30 pounds of air in it, the other has 10 pounds. You put them against the wall, you take a picture, they look identical. People say, there's no problem here, but put them on the car and you'll see there's a problem. And that's where spine imaging hopefully is going in the future. We're doing some work in that in St. Louis, and it's very promising. We're finding problems in people where the standard response will be, we don't see any nerve root compression, so they must be fine. These people clearly aren't fine. We owe all of the initial work on imaging to Marie Curie. Does anybody know who Marie Curie was? Marie Curie was a Polish woman, actually. The reason her name was Curie was because when she was young, you couldn't go to universities in Poland if you were a woman. So she went to Paris and studied at the Sorbonne and became a physicist and married a French physicist named Pierre Curie. And the two of them together discovered radium, first radioactive element, and polonium, which she named after Poland. For that discovery, she got the Nobel Prize. She was the first woman to get a Nobel Prize in the history of the prize. And not only that, she got that prize in 1903, and in 1911 she got a second Nobel Prize. So she had Nobel Prizes in physics and in chemistry. And if not for the work she did, we wouldn't have X-rays. Interestingly enough, 100 years after Marie Curie got the Nobel Prize for discovering these radioactive things that enable us to do X-rays, the Nobel Prize was won in 2003 by 3 physicists who made possible MRIs. So the whole scientific basis for spinal imaging, or any imaging for that matter, came within a 100-year period. The picture that you're looking at now is the very first X-ray ever taken. This was taken by Wilhelm Röntgen using radioactive materials of his wife's hand, and that's her wedding ring. This picture's actually as good as many X-rays we see nowadays. The very first recorded picture of a plain X-ray. And early in the 1900s, people were able to get X-rays of the spine. And these were mainly used to diagnose fractures. Now, what are you looking at? You're looking at the vertebrae, you're looking at the bones, you're looking at a lateral image here, which is a side image, and an AP image here. And both of these images are very helpful in seeing if somebody had a fracture. They didn't give you any information at all about what was happening to the nerves in the spinal canal. And at that point, it didn't really matter because people weren't operating on the spine. They didn't know what to do or how to do it, and so imaging of it wasn't that relevant. But it was very important, they learned early on, to look at things from multiple angles. This is a slide my daughter gave me, and she said, this is why it's important to look at things from more than one point of view. So, shortly after X-rays were developed, a French doctor was doing a technique where they would inject lipids into people's muscles to relieve pain. It was a little bit primitive. It was kind of like bloodletting. It's not done anymore. But he accidentally injected this oil into the spinal canal, and he panicked. He didn't know what to do. It went in where the nerves were. And so what did he do? He did what we always do when we don't know what's going on. He got an X-ray. And lo and behold, what happened with the oil was it lit up the nerves, and you could see spinal stenosis. So for many, many years, the diagnostic tool looking for disc herniation, spinal stenosis, was the myelogram, it was called it, because they put dye in on an X-ray, and you could see what was going on with the nerves. We still do myelograms, but putting oil in the spine is very bad, so we use a water contrast, water-soluble dye now, and that's what a myelogram is. They're still in use. The next thing that came along in the 60s was the CAT scan. This isn't a CAT scan. And a CAT scan is basically a big X-ray tube in a circle, and you take pictures from all angles, and then the computer reformats those. And not only can you look at slices of a bone, and it is an X-ray, so you're looking primarily at bone, you can look at it from different angles. You can get a side view, you can get a top to bottom view, and a front to back view. We call those lateral or sagittal, coronal, and axial views. So this is an example of a CAT scan I obtained on somebody who had surgery and wasn't doing very well, and their doctor got an X-ray and said they had a solid fusion. Well, an X-ray integrates over the portion that you're looking at. It's like looking through a thick frosted window. Everything is in one plane, but you're really looking through several dimensions. A CAT scan can take slices of a millimeter thickness or less, and you can see that this fusion clearly isn't solid across here. And you can see that in both views. So that's one of the things you can do with the CAT scan. Next thing that came along was combining the myelogram with the CAT scan for CT myelogram. So what do we see here? Anybody know? See if you can say it again. Spondylolisthesis. Here's the dye in the canal, and it's completely blocked here. This is called a complete nerve block. And the reason it's blocked is because of this slip. The spinal canal is made up of rings at every level, and when you slip one forward on the other, you cut the material in the middle. So this is a CT myelogram. We still do these. Very, very helpful. The next thing that came along, and it first came into use in the late 70s, early 80s, is the MRI. And the thing people comment about MRIs is very claustrophobic, it's very tight, getting in an MRI. So what it is it's a magnet. It's a great big magnet. It gives you no radiation, and an electrical field is circulated around it, and it spins the electrons in your body. It actually lines them up and polarizes them. And what it does is it measures water content. It's very good for looking at soft tissue. And here's an example of a cervical MRI. You can see the spinal cord here. You can see the bones. It's not as good at imaging bones as CT is. You can see the disc. This patient is an artist who had prior surgery. I met him. He was myelopathic, meaning he had spinal cord injury type symptoms. He had a 3 millimeter spinal canal here. You can see his cord is getting crushed here. You can see some damage in his cord. And I actually operated on him, decompressed all of this, and he's back to painting. He sent me a picture of 5 paintings. If anybody was at my talk a few weeks ago, they saw the paintings this guy did. So surgical diagnoses and pathology. We, as allopathic physicians, that's what most MDs are, allopathic physicians. We make a diagnosis based on signs and symptoms and studies, and then we treat the diagnosis. We make the diagnosis and we treat these. These are some of the things we treat. This is the large majority of what I treat as a spine surgeon. Herniations, arthritis, curvatures, stenosis, which you now know what it is, spondylolisthesis, which hopefully you can say by now, fractures, dislocations. All of these things have 3 things in common. They represent a combination of nerve root compression, instability, and malalignment. And anytime we treat one of these conditions, we're treating some combination of that. Let me give you an example. If we treat a disc herniation, sometimes we can make a little incision, go in, clean it out, and that's all the patient needs. They go home in 3 hours and they get some therapy, and the results on that can be remarkable if somebody's in horrible pain. Sometimes when somebody has a disc herniation, there's instability associated with it. And if there is, it's very important to recognize it and fuse it before they come back with a recurrent herniation. If you think it's going to be unstable after you take the disc out, if you think it's going to have a recurrent herniation after you take the disc out, if it's obviously unstable with a spondylolisthesis, then you fuse it. The idea is to fuse it the first time, to do the last operation first. It's very traumatic for people who have multiple operations. The other thing about spine surgery is it's different than plastic surgery. If you're a plastic surgeon and you operate on a kid 10 times, people will say, wow, what a dedicated doctor. If you do 2 spine surgeries, you're considered a failure. So principles of spine surgery: we decompress the nerves, we restore alignment, we stabilize the spine. What are some of the procedures we do? Discectomy, simple microdiscectomy through a 1-inch incision. For somebody with spinal stenosis or somebody with a big disc herniation, you take the whole back lamina off and do a discectomy if needed. Fracture surgery, I'll show you a picture of that. Fusions, again, if you think it's going to be unstable, if it obviously is unstable, then you fuse it, the first time hopefully. Scoliosis surgery involves a long extended fusion with rods and screws and bone grafting and straightening the spine out. Revision surgery, a large part of my practice is seeing people who've had surgery and didn't do well. We try and figure out what's going on. If somebody's had a fusion and they don't do well, make sure that doctor has gotten a CT scan to very meticulously assess the fusion before they sign off and say the person's fine. It's a very traumatic thing for somebody to have an operation and not be fine and have somebody tell them they are fine, because we usually blame the patient. That's not a good way to go. Here's an example of a disc herniation we operated on recently. 1-inch incision, go in with the microscope, clean it out. Patient did well. Here's a fracture. It's an unstable fracture. You go above it, you go below it, you put rods in, you put bone graft in, you stabilize it. And that's pretty much all I have. I hope it turned out like this. This is a picture of my babies. And here they are a few years later. This guy came along later. So now that you know as much as I do about spine surgery, we can take a look at our patient.
Looks like he's slowly making his way to the appointment. Doc, you may want to make sure he's got a chair. He doesn't look real good. There's one behind the
I
screen.
need a bed. Mr. Hall, pleasure to meet you. I think there's some inconsistency in your exam because based on everything I know about you, you're limping on the wrong side. So you have right low back pain, but you're limping on your left leg.
It's my right hip is where all my pain's at. It's right here.
You know, I don't always get it right the first time, so we're not going to start judging you right away.
Okay.
So tell me what happened to you.
Well, I was in the shop. Customer came in, immediately pushed me into the lift, the hydraulic lift that was behind me. I hit my back against it. And as soon as I hit my back against that, I knew something wasn't right.
Was it violent?
Well, yeah.
Oh, okay. Are you a pretty healthy guy?
Yeah, perfect health. I mean, look at me.
Have you ever had any back problems in the past?
Never.
That's what they all say. You don't smoke or anything, do you?
Nope.
What is that behind your ear?
That's my brother's. That's my brother's.
Oh, your brother's.
Yeah, I'm holding on to that.
Keep that behind your ear.
Yeah.
Okay, now, if you need surgery, we routinely, not that you smoke or anything, but we get a test to make sure the nicotine's all out of your body. We're like Ronald Reagan with arms control. We trust and verify.
How many weeks does that pick up?
Pardon?
How many weeks does that pick up?
4 weeks. So if there's any nicotine in your body...
No, there won't. There won't be.
There won't be?
No.
Okay. Now, we used to do urine tests, but people would take their friends to the lab with them. So now we do blood tests.
Okay, that's fine.
So you've had physical therapy, right?
Yep.
You've had a few epidural steroid injections.
Yep.
You've treated with Dr. Cantrell over there.
Yep.
These are tests, so if you're not better, you probably need surgery.
Okay.
You okay with that?
I mean, at this point, I'm pretty desperate, so whatever I can do to relieve my pain.
Okay, well, let's talk about surgery a little bit. But I want to preface that with something. For about 20 years, I've been grilled by lawyers from all over the state and around the country, defense lawyers, claimants lawyers, and I'm expected to know the answers with a reasonable degree of medical certainty. So I'm going to turn the tables and I'm going to ask the lawyers some questions. Miss Shock Legal, do you know what part of the body we're looking at here?
Well, first, it's shock legal, not doc legal, so bear with me. It's the spine.
Yeah, I'll caveat this. A judge who I respect once said, doctors shouldn't practice law and lawyers shouldn't practice medicine.
Amen.
Best advice I've heard.
Is it the lumbar spine?
Very good.
And is it L5S1?
That's correct. What do you see here? I'll give you a clue.
Oh, do I have to pronounce this stuff? Where?
Okay, here's L5, as you said, and there's S1.
I see spondylolisthesis.
Very good. Okay. Miss Drew, do you see a crack in the bone back here?
Fracture.
That's,
Is that right?
That's generally true, but is it a specific kind of fracture?
Transverse. Beth says transverse. Is that right? Pars defect.
That's very good, yeah.
Yes. Thank you.
And the other name for it is?
A pars fracture.
Well, that's what you just said.
Thank God it's not broken.
You could help her if you... It begins with spondylo. If you get the rest, I'll give you full credit.
Spondylo, what did you say? Listhesis? So, spondylolysis.
Very good. You get full credit. Okay.
Good job, Nancy.
Next slide. Ms. Miles, what kind of study are we looking at here?
What type of study are we looking at?
Yes.
That looks like a CAT scan.
I'll give you another chance.
Well, I mean, Doc, you know my clients just have pain. And we don't do records and stuff.
I'll give you
We
a
just
hint.
ask for
It
money.
begins with an M.
Maybe an MRI.
Very good.
There we go.
Yes. Okay, Lori, can you see the MRI from there?
Can you get
Yes.
Okay, so we know, thanks to Ms. Schocklegel, that there's spondylolisthesis here, but do you see something else here?
I am a defense attorney, so I'm going with a disc bulge.
Yes, some would say that, yeah. Okay, now we're looking, one more question down there for Mr. Dalton.
Pass.
You can't get out of this.
I
I couldn't
can't?
get out of it for 20 years.
Can I have, wait, can I object?
Jack.
I can't hear him.
He said he objects.
Okay. Okay, well, I'll make it easy. What side of the body is this on? We'll go back to it. What side of the body is this on? We're standing at the patient's
right.
feet, and we're looking up.
The right?
Very
What is the
good.
right?
You had a 50%
You had a 50-50
chance
chance.
of getting that one right.
I usually get those wrong, but that's okay. Today it's different.
Left is right. Left is correct.
I guess I got it wrong.
Okay, so here's another question. Anybody on the panel? Here's a guy with a disc herniation and spondylolisthesis. If he injured himself in the garage incident, what did he do? Did he get the spondylolisthesis? Did he get? Correct. He didn't. But amazingly, this guy never had pain before in his life.
He's a liar,
What happened to him at the time of his injury?
He bulged his disc.
That's right, he bulged his disc. And frankly, it doesn't matter if it's a bulge or a herniation or an extrusion. What matters is if it's compressing nerves. And on this picture, you can see the nerve on the left, and you can see a sliver of the nerve on the right. So what does he need, having already been skillfully treated by Dr. Cantrell?
A good lawyer.
A good lawyer.
Fusion. He needs an arthrodesis, that's right, fusion.
Why not a discectomy?
Because this is trying to slip off, and if you take off some of this bone back here and take the disc out, each one of these, with respect to the one below and with respect to the one above, is like a three-legged chair. The disc space is the front leg, the joints in the back are the back legs on the right and on the left. We already know he has a bad front leg because the disc's herniated, and we know that this is separated from the front because of the spondylolisthesis. So if you are a young aspiring surgeon and you say take the disc out and leave the fusion, leave it without a fusion, you flunk your boards. So.
Are we going to do an autograft or an allograft?
I told you I'm the surgical equivalent of an earth mother, so I use the patient's own bone. And I fix it in the front, and I fix it in the back. And here he is after surgery. So fast forward, how are you doing?
I feel great. No pain.
Are you still taking narcotics?
Nope.
How many days did you take them for?
Only about 3 or 4 days.
Can we see you walk across the floor there?
Yeah.
Very good. Okay. Make sure your attorney knows how well you're doing.
I think we may have a couple questions for you, Dr. Quill. A couple came in. I want to get the one with the hand up first, and then a couple came.
One thing that spondylolisthesis, is that naturally, I mean,
There are many different kinds. The two most common are the isthmic spondylolisthesis associated with the spondylolysis. And so the spondylolysis occurs early in life, and as time goes on, the joints get a little arthritic, the disc gets a little desiccated and starts to slide forward. So it's a combination of an early injury or congenital defect associated with time. The second kind of spondylolisthesis does not have the spondylolysis, and in that, it's pure degenerative change. And the facet joints become incompetent, and the disc becomes incompetent, and the whole unit on the top slides forward. In the isthmic spondylolisthesis, the front part of the body of the top vertebrae slides forward, leaving the back part with the vertebrae down below. It's hard to visualize. If I had some pictures, it would be obvious. There's another kind called a traumatic spondylolisthesis, extremely rare. This is in high-energy motor vehicle accidents and things. I've never seen one. Welcome.
Okay, Dr. Coyle, just a couple questions from the crowd. Can you please discuss the use of a weight-bearing MRI?
Yes, that's an attempt to mimic physiologic function. In other words, we take an MRI with somebody lying in a tube, and the back does not look like it does when you sit, stand, walk, bend, and twist. So to put some weight on it forces it to a different direction. I've seen a lot of people experiment with this. The problem essentially is, how do you visualize something with a snapshot when people don't live in snapshots, they live in motion, in time. I haven't seen very good quality weight-bearing MRIs. One of the things people did years ago is they tried to put reverse traction on somebody. In other words, put them in an MRI, put shoulder pads on them, and pull down on them such that you were mimicking weight-bearing. But there was so much liability associated with doing that in patients who already had problems that that experiment was stopped. There really isn't anything equivalent to echocardiograms or ultrasounds where you can look at things moving. There's also a sitting MRI, and the problem with that is that the field strength of the magnet isn't nearly what we have in some of the supine or lying down MRIs. One alternative to this, although we can't see what happens to the spine when somebody's moving, is we can anesthetize the area. And that's a good way to determine what the pain generator is. And that's something I've been doing with Dr. Greg Smith for about 10 years, and results are remarkable. People come back and they can't believe they have no pain. Unfortunately, it doesn't last. If it did, we'd all be out of business too, but it works, and it gives us a very good idea whether or not somebody's going to do well with surgery. The problem is, somebody looks at the MRI and it looks pretty good, and they say, you know, there's nothing here to operate on. You get a peer review and they tell you, well, surgery's not indicated based on that. There's no compression. But they don't know what happens when the person gets up and moves around. So doing anesthetic injections, this isn't a discogram, it's an anesthetic injection. We don't try to create pain, we try to relieve pain. If you can relieve somebody's pain completely by just injecting at one level, that's a very good idea. Number one, where the pain's coming from. Number two, that you can relieve it if you operate.
We've gotten a couple questions that are similar. What are your thoughts about disc replacement surgery?
I don't like artificial moving parts. Now, they're necessary to some extent. There are a couple of studies that were done, major studies that were done. There was a study by a doctor at the Hospital for Special Surgery in New York where he looked at 200 patients that he had done a fusion on. And he said, if I was going to do a disc replacement surgery on them, how many would be candidates? And there are certain contraindications to a disc replacement. Prior surgery, say, let's confine this to lumbar disc replacement surgery. A prior laminectomy is a contraindication. A lot of arthritis is a contraindication. Stenosis is a contraindication. Spondylosis is a contraindication. He looked at 200 patients. He did not find a single one that would be a potential candidate for disc replacement surgery. The president of the North American Spine Society saw that study and he said, that cannot be the case. I can't believe that you looked at 200 patients and they were all had contraindications to a disc replacement. So he did that study and his patients found the same result. The long and the short of it is, for certain select very narrow group of people, disc replacement surgery is helpful. I don't think you lose a lot of motion when you fuse 1 or 2 segments in the low back. Most of your motion when you bend over comes from your hips. You put your hands on your pelvis and bend forward, your hands are going to move because your pelvis and your hips are where you pivot. You get 5 or 6 degrees of motion per level, and that's not a lot to sacrifice to get pain-free. Once you have a fusion, you're home free on that level. When you put a disc in there, you're more susceptible to infections. There's really no good answer as to what you do when that disc fails. There are plastic components in there, and I tell people, if you have any 20-year-old plastic in your house, you'll have it in your back, and it'll be like that 20 years from now, and 20 years goes fast.
Next question, in the x-ray on the screen, will the metal anchors weaken the vertebral bone, or will the one grow around it to strengthen it?
It's a good question. There's something called the modulus of elasticity, and it's a measure of how elastic something is. Everything has some degree of brittleness and some degree of plasticity, meaning it bends. Those are much more brittle than bone, but they don't need to come out, but they're only there temporarily to stabilize the fusion. Now this person, you can see, has a solid fusion here. We fused it in the front. He's solid in the front. It sounds kind of morbid, but they have had cases of people who died years later after this. They biopsied the bone in the front, and the bone that you put in, that donor bone, has the same DNA as the patient, meaning the patient's body replaced all of that bone with other bone. The other thing is that as long as you get a solid fusion, that hardware's safe. If you don't get a solid fusion, eventually it will loosen up or it will fracture.
Anthony Michael Hall talked about not smoking. Can you please explain the role of smoking in a fusion candidate?
Yes, there are a number of things that smoking does that are detrimental to getting a fusion. A fusion needs a few things. It needs a high oxygen content, and it needs stability to form a fusion. If you don't have a high oxygen content, you form scar instead of bone. And so somebody who smokes is getting nicotine, which narrows the blood vessels, and it's fat soluble, so it stays in the body for about 30 days. If you smoke a cigarette 3 weeks from now, we check your blood levels. You'll have nicotine in your blood. It's not like a water soluble thing that will be excreted right away. So nicotine narrows the blood vessels. Carbon monoxide is in the cigarettes, and that comes out the back end of the cigarette, and it attaches to the hemoglobin molecule. That's the molecule in the blood cell that carries oxygen to the body. So basically, you're trying to heal something, and you're bringing carbon monoxide to it. It's like having the back end of your tailpipe going to the bone you're trying to heal. There are studies that show that if you do a fusion, the failure rate can be as high as 40% per level in the lumbar spine in people who are actively smoking. Now, what does that mean if you do a 2-level fusion? It means your success rate is 60%, and your success rate for a 2-level fusion is 36%. I don't think anybody would want to have surgery with those odds.
Those are all the questions I've gotten texted.
I have a question. What causes popping in your neck? I'm asking for a friend.
A close friend?
Yeah, very close friend.
Very close. Yeah. 2 things can cause it. One is bone spurs or spondylosis, and the second is the facet joints can cause it.
So arthritis.
It's like cracking your knuckles.
Yeah. Okay.
Thanks.
Dr. Coyle, what'd you rate our hero at? What's our rating?
Good call.
Nancy was going to make it up, but I thought I'd grab you and ask you.
So the rating is 15% on the injury and another 5% on the spondylolisthesis, which was pre-existing even though it was allegedly completely asymptomatic. I've always been told I rate too high by the insurance companies and too low by the claimant's attorney, so I guess I'm right where I need to be.
Thank you.
Thanks, doctor.
I guess if we need him back, we can say spondylolisthesis 3 times and click our heels. All right, just a quick recap. Again, we're 9 months out. Anthony Michael Hall has finished treating, and Roland in the Dolan is still trying hard for his money. Money Miles is still keeping her fingers on the pulse of everything, and I think we're going to dive into the work comp side of it.
Hello, Elizabeth Schock Legal here.
It's Nancy calling on the Anthony Michael Hall case.
Hi, Nance. How are you?
I am just fine.
Good, good. I saw that he's done treating with Dr. Coyle. Is that right?
Yep, released and had a great result, and he's ready to settle. You know, we are living in a material world.
I love the ones that stay away from those plaintiffs' attorneys like that Money Miles. He's still pro se?
Yep.
All right. All right, Nance, so before we talk settlement, in the beginning of this case, you told me that he had some unauthorized treatment, went to the emergency room, had an MRI, and you indicated we hadn't paid those bills. What's the status of that? Have those bills been satisfied?
Nope, I didn't authorize them, and I'm not paying them.
Whoa, whoa, whoa. Well, let's go over whether we're going to be liable for these bills ultimately, Nancy.
Okay.
All right, so stepping outside of character here for a minute. You know, this comes up a lot in our cases, especially those ones that we investigate in the beginning and maybe we don't pick up treatment right away. You know, the nice thing about Missouri is that we get to direct medical care. So if it's going to be compensable, it's great to get a handle on that right away. So we're not racking up a bunch of unauthorized medical bills that we have to deal with. So the relevant part of the statute, 287.140.1, basically goes over, you know, that the employee shall receive and the employer shall provide medical care reasonably required to cure and relieve the effects of the injury. So the employer is burdened with providing medical care that cures and relieves any effect of the injury. It also provides that if the employee desires, maybe if you can go back to the other slide, thank you. If he desires, he or she desires, he shall have the right to select his own physician, surgeon, or other such requirement at his own expense. So nothing prohibits an employee from going and treating on their own at their own expense. You just get into situations where that treatment can be put back onto the employer. A thing to point out here is this reasonableness, and that's not a very high burden for employees to prove. We have judges all the time, especially in the realm of emergency care, going to the emergency room, indicating, you know, I think that was reasonable. So in this case, I think Ms. Drew's going to be upset. But the other thing that we want to make sure that we know, Missouri courts have routinely held that employers have to pay some of those unauthorized medical bills in certain situations. And those certain situations include when an employer fails or refuses to provide medical care. So if you know someone is hurt and needs medical care and we fail to provide it, ultimately those bills could come back to us. We get into situations all the time, especially in recent years, where we've got MMI status and all of a sudden we're getting a call from Money Miles saying, my client needs more treatment. And then we have to make that call whether we're going to refuse and deny further care. And if we do so, we just need to know that if they go off and rack up a bunch of bills that a judge thinks is reasonable and related, that could come back on us also. So it's just important to keep that in mind. Let's get back to Ms. Drew. Nancy, did you learn anything?
Of course I did.
Okay, so basically, because it was emergency care, because he ended up having a disc herniation, because he ended up having surgery, I think that it was reasonable for him to go to the emergency room, get the MRI, I think that ultimately we're going to be found liable for these bills. And since Mr. Hall is pro se and hasn't retained counsel, it probably behooves us to deal with those bills one way or another rather than hold up the settlement, force him to go get an attorney, and then we're looking at a lot more exposure.
I totally agree. Okay, Dr. Coyle rated him at what? 15 with 5 pre-existing?
That's correct.
Okay, so I say I'll give you up to 17 and a half.
Perfect. And we know, majority of us in this room know, that if he were to go hire an attorney, we're probably looking more along the lines of 25%, 27.5% for a single level fusion. So let's try and get this while he's pro se.
Okay, can we get it on the docket soon?
Absolutely. I'll see if we can get him on the walkthrough docket, or we can file for a request for conference, get him before the judge, and hopefully resolve it with him. Okay?
Okay.
All right. Warning, I'm going to sing again. Abra, abracadabra. We're settled, Nance.
You know, you are simply the best.
Ah, sweet child of mine. It takes two to make a case go right. Don't you forget about me.
Wouldn't dream of it, girlfriend.
Now that the work comp claim has concluded, let's check up on Mr. Rowland, who appears to be growing very impatient.
Very impatient. That Lori Ringwald better have my money by now. Ring.
Tell me lies, tell me sweet little lies.
Hello.
Let it ring long enough. I mean, geez. Lori, this is Roland calling. You've had this case for about a year now, and it's about time to pay.
Hey, Roland. You still rolling in that Dolan, or are you spending it all on this one?
I don't have time for your shenanigans. I'm going to be sending you a time limit demand for policy limits. And I'm warning you, it's going to comply with that new 537058 statute.
You comply with the law. I'll believe it when I see it.
A blind squirrel finds a nut. Yes, and that means it's going to come certified in mail. And I'm going to comply. And that means you're going to have 90 days from the date you receive it to respond. And it's going to have all the necessary documentation, including authorizations, a list of providers, injuries, location of loss, claim number. Everything's going to be released. You know the drill.
Yeah, I get all that, Roland, but as you said, it's only been a year. What really makes you think you're all of a sudden entitled to my policy limits?
You literally just gave a presentation on it.
Hey, at least you listen.
Foreseeability couldn't be more clear. The mere fact that Jack employs only ex-cons makes it foreseeable. And we both have the stack of police reports from Jack's shop and the surrounding areas. You've seen the level of violent crime in the area, and don't kid yourself. Jack did nothing to institute policies, procedures, or additional security measures to even support an argument that this wasn't foreseeable.
I don't recall having the burden of proof here, Roland.
Listen, the risks you run in taking this to trial are insane. It's like jumping out of a plane without a parachute and hoping you land on a pillow. You have a chop shop which employs cons in a bad area with no security. The jury is going to despise your client and what his business has done to their neighborhood. I'm getting compensatory and punitives. You blow this up, and Jack's insurer is staring down the barrel of an 8-figure bad faith case.
Keep puffing your chest, Roland. Listen, there's no way the medical would warrant the damages you're asking for. And the lost wages that you're claiming, you have no documentation to support that claim, given that your guy, Magnum PI, has no viable income. If he wouldn't take all his cash under the table, maybe he'd actually have a claim, but you don't. So all you have is your medical. Right now, the total paid after adjustments is only 15 grand. I don't care about the charges, so don't even start talking to me about that. It's about the total paid. Even if I wanted to throw you a bone, which we all know I never do, and agree that the punitives were a risk, there is still no way that you can legitimately think this thing is worth $1 million.
Lori, you know how this game goes in Missouri now. I'm not going to submit any medical bills to the jury. All those sheep will hear is that my client was shot in the leg, which broke his tibia. It required emergency surgical intervention. He was immobilized for a long time. It was a life-altering and maybe life-threatening injury. He'll never be the same. The jury is going to automatically assume the medical is in the 6 figures. And you have no recourse to cure those fantastic assumptions.
So we get to play the game called Hide the Bills? I love that game. Whatever, Roland. I'm late for a depo. Shoot me over the demand, which I doubt will comply with the law. I'll take a look at it.
Well, don't stop believing, Laurie. You'll get it soon enough.
I better give Money a heads up.
Money Miles, I got you on speaker, so watch what you say.
Hey, Money.
Hey, Lori.
Just got off the phone with our buddy, Roland Dolan.
That guy. He thinks he's all big bucks, no whammies, but he's sadly mistaken. What's he want now?
Oh, you know, just gonna issue a little policy limits demand. He claims it's gonna comply with the statute. I highly doubt that, but wanted to let you know it's coming. Jack has a business owner's policy for $1 million. Roland, of course, says he wants it all. We're gonna have 90 days to respond once we receive it pursuant to 537.058. Roland claims he's gonna get the money or set up the insurance company for bad faith. Either way, he thinks he's getting 7 figures. I'll be sure to shoot you a copy when I get it.
You know you shouldn't joke about shootings on this one. But you know what? I'll run with it. So, Roland doesn't have the ammo to set up the insurer or Jack's business on these facts. The damages are minimal, and no jury in their right mind would award more than $1 million to that sketchy PI.
I agree, Money, but you and I both know we got to keep in mind the risk that Roland's punitive damage claim plays in potentially exposing Jack to personal liability outside of his policy coverage.
Exactly. Jack and I talked about that. Oh, hold it. I got another call. Speak of the devil. Yo.
Money, it's rolling. I like you. It's time to play nice. And
Do
I'm
you
gonna
want a
give
cookie? I
No.
mean, I like you too. What?
I don't really like you. I just want money. So
All right.
I'm going to give you a heads up. I'm sending you a demand for the $1 million, which are Jack's limits. Jack can still come out of this without any exposure if you play this right. And you know, as his personal counsel, that's all you care about. So you need to put the hammer on Miss Lori and his insurer and get this deal accepted, because if not, it will certainly be an excess judgment.
In excess? What? They're on tour. That band doesn't care about your case. Anyway, I'll review the demand when you finally send it over, but don't call me threatening about demands I don't have.
Whatever.
I'll talk about it with Lori.
They're your convicts.
What? Regardless, this case is never worth policy limits, and I pity the fool that calls money's phone with inflated settlement demands. Goodbye, Roland.
Well, there it goes. I just sent the demand to Lori. The clock is ticking.
This is Laurie.
Did you get my $1 million yet?
Hello to you too, Roland. Frankie says relax. Don't do it. I just got your demand. You know I have 90 days to respond. Why are you so antsy? Struggling to pay your bills, Roland?
I don't even know what it means to struggle. What I do know is that my guy Judd decided to accept requests to appear on radio shows and put It's Jacked Up on blast. He's going to tell a story to the world. Innocent man gets shot. I've lost my place in my script. Take 2. Innocent man gets shot by convicts employed at a local auto shop. Listeners are going to eat it up. Just think of the influence on that jury pool and the impact on Jack's business. I bet with his personality and the popularity of Magnum PI, Judd is going to become a radio star.
Oh, Roland. Poor Roland. You'll just try anything possible to put pressure on with smoke and mirrors in an attempt to get paid money to which we both know you're not entitled. Same old story with you. Oh, my case sucks. Tear. So let's find other ways to try and squeeze the insurance company.
Squeeze? I don't squeeze. These aren't threats. My radio star client is entitled to the million, and you know it.
So, you think you have a radio star, huh? Well, you clearly haven't done your homework on this one, Roland. While you were busy being an agent, booking your client for gigs on radio shows, I've actually been working up this case. I did all the legwork on obtaining all the police reports for 5 years prior on this property and all the surrounding properties, which we talked about earlier. Crunching the data and confirming Jack's property has a lower violent crime rate than the surrounding properties. So clearly, our security measures are working. But even better yet, guess what?
What?
Chatted up some witnesses.
Who needs witnesses? My guy has a bullet lodged in his leg.
Obviously, you haven't done these type of cases before. Witnesses are key. Now, you know that under the Business Premises Safety Act that went into effect last summer, a property owner has no duty to protect against criminal acts of third parties, but there's only one exception. If the owner knows or has reason to know that the acts of the third parties are occurring or about to occur, and there's sufficient time to prevent the crime or injury. Jack wasn't there when Emilio arrived and didn't even know he had been called up to the shop. There was no time for him to prevent the incident, which will be supported by the witnesses. But the real kicker is the video.
Whatever, we've all seen the video. It cuts off before the shooting. So what does that have to do with my case?
Yeah, that's true. I mean, the surveillance video failed to capture the shooting, but turns out when you chat up some witnesses, another video might pop up. That witness happened to record the whole thing. I just got that video, and it clearly shows your innocent radio star being the first to pull the gun. Emilio shot your innocent radio star in self-defense, and it all happened in just seconds.
You're lying, as always.
Nope. So guess what, Roland? You get to play this one of two ways. You can voluntarily dismiss your case, or you can put in the time and effort to fight a motion for summary judgment, which we both know I'm going to win. I'm going to win it based on the standards in the Business Premises Safety Act we all learned about in Laurie's little seminar earlier this morning. The court's going to find that Jack had absolutely no time to prevent this shooting, and your radio star is the one that instigated the whole thing. Emilio was justified in defending himself. I'm sending the video to you right now. Take a look, but keep me on the phone.
All right, well, I'm going to put you on speaker because I need both hands.
That works. I just want to hear your reaction.
As I pull it up.
Did you get it yet?
No.
Take a look, Roland.
We have dial-up. 1 second.
Looks like that video just killed your radio star.
I saw it.
Good luck, Roland.
Damn you, Lori from Remington Dixon!
Oh, Sean, bravo.
Thank you.
Dramatic.
Well, Roland's been crying for several months now. So let's check in on Lori Ringwald and Money Miles.
Money,
You
that
know it's
ringtone
money.
just keeps playing.
Yeah, it's a theme. I told you I'm trying to run a business.
I
Money
know.
Miles
I
Incorporated.
see it on your commercials every morning.
As you should. Do you see the one late at night when I'm walking around in the park with my brother? Have you seen that one?
Is that the guy with the eye patch?
No, that's a different guy.
Okay.
No. Okay. Anyway, what's going on?
Money. As you know, Roland wouldn't go quietly, so we had to file that motion for summary judgment a few months ago. You know, based on that new evidence we got.
Right, that video.
Well, we just got the ruling.
And, come on.
It's over.
All right.
Court ruled in our favor, granted the motion for summary judgment. Roland, well, he's crying again, but this time it's over the expenses he has in on this one. He's no longer rolling in that Dolan. I don't think he'll be appealing.
Hey, fabulous. So you finally got tattoo off Fantasy Island.
Whose tattoo? I don't get it.
What? Ricardo Montalban, remember? He had the white suit and like the guests would come and they could get wishes and go fly to the other. Okay, well, anyway. So, thanks for calling with the good news. That's still another win in the books for me and my clients. And you didn't do so bad either, Lori.
You're as humble as ever, Money.
Whatever, Miss Ringer. You know every case needs a little money. Either way, another one down.
And another one down.
At this time, I'm going to introduce, thank you.
Yay for us. Good job, y'all. Good job.
At this time, I'd like to introduce Maria Doherty. She's a senior associate at Evans & Dixon. We like to refer to her as the keeper of the case law. She's going to come up and talk about a few things, and then we got a little bit of wrap-up, and then we're almost done. Maria?
Thanks, Steve. Good morning, everyone. We had one question pop in during the last session. Ms. Shock Legal, walk-ins, they still exist? How do we get one? When do they happen?
They do exist in a formal manner in St. Louis. I'm not sure about in other venues.
St. Charles.
St. Charles. But in St. Louis, Judge Attenad is the walk-through conference guru. So he will add cases that are pro se, settlement's been reached, you have a rating, the claimant's ready to go. And I just signed one up about a week ago, and it's for June 13th. So he's running about I'd say 4 weeks at this point. And then in St. Charles, I think it's Judge Koner.
Yes.
But then on the other thought process on that is, if you go to the right judge, he or she typically will entertain you bringing in someone to
Beth,
try and walk
I'm
through
getting
something
notes
too.
that you should talk louder.
That I should talk louder?
Yes.
Oh my.
They have to get Sherry.
There's a few other judges.
I'm reading mixed signals. I'm
Oh.
sorry.
I was going to say, no one's ever told
You need
me
to be
talk
better with
louder.
those
It's
charades,
usually shut
Alex.
up.
I've got Karen from Springfield, too. And
In Springfield, so Springfield, Branson, they are still setting walk-ins, same conditions, pro se, settlement already reached. They do those on Friday mornings between 9 a.m. and noon in 15-minute increments. We can usually get those set within 2 or 3 weeks, depending on, usually it's the schedule of the claimant that's a problem. So they're still doing those. The other dockets that we cover, West Plains, Joplin, those all need to be done through a conference setting, although sometimes we have luck getting them set quicker, but usually it's just a conference request.
All right, now the fun part, case law. For those of you who don't know me, my name is Maria Doherty. I have been with E&D for 3 years now. Prior to this, I defended the Second Injury Fund with the Attorney General's office for 4 years.
yeah, just maybe stand just a shade closer to that. So.
Closer? You want me to be louder?
Louder would be good, too.
All right.
Well, we got this guy coming out. Everybody, this guy.
This guy.
Does that work? Is that better? Okay. All right, so I just have 2 cases for you I'm going to discuss. The first is Danny Harris versus Rawls County. This is a commission case from January of 2019 this year, where the claimant injured his low back while lifting a tire at work. He was treated conservatively with some physical therapy, some injections, and ultimately released at maximum medical improvement. The experts that provided treatment and independent medical examinations retained by the employer included Dr. Cantrell, who was here, Dr. Coyle, and Dr. Bernardi. Claimant had a whole host of issues after his release at MMI. He spent some time in jail, his spine deteriorated, and by the time that this case got tried in November 2017, he had been using a cane because his legs would give out and he'd fall down for no reason at all. Several of the x-rays, MRIs, CTs, and EMGs did not show radiculopathy. They did show spondylosis that Dr. Coyle talked about. The objective studies did identify consistently these degenerative changes in the spine. Mr. Gary Weemholt, who is a vocational expert, found the claimant unemployable in the open labor market, and the good James England, retained by the employer, disagreed and found that he was, in fact, employable. Judge Joseph Dennigan, St. Louis, determined that the claimant was permanently and totally disabled from this work injury. This meant that permanent and total disability benefits would be paid by the employer for the rest of claimant's life. He also awarded future medical treatment for the low back and as well as for depression. The employer correctly appealed this decision. Ultimately, the commission overturned the administrative law judge's decision. The commission found that the work incident did result in a compensable injury, but that was determined to be a back sprain alone. The commission really focused on the fact that where medical opinions are inconsistent or conflicting, which is the case in every workers' compensation fact pattern, the objective medical findings shall prevail over subjective medical findings. I'm going to say this again because it sounds so sweet. The objective medical findings shall prevail over the subjective medical findings. The commission found Drs. Cantrell, Dr. Coyle, and Bernardi to consistently conclude that the majority of the claimant's symptoms were from the degenerative and as well as congenital conditions which were objectively identified through testing. Not only did the commission overturn the finding of permanent and total disability, they only awarded 5% of the body as a whole for the lumbar sprain. They also overturned the ruling that claimant was entitled to future medical care. The employee representative on the commission, who's Curtis Chick, who I would have expected to write a very passionate dissent, instead wrote a short, separate opinion concurring in part and dissenting only with relation to the amount of PPD that should have been awarded. He thought it should have been 10 instead of 5. So the takeaway from this case is, again, that in determining compensability and disability, where inconsistent, conflicting medical opinions exist, the objective medical findings shall prevail over the subjective medical findings. Now, this sounds like a novel concept because it's been a while since the commission's really looked at it and focused on it, but it's been in the statute for years just waiting to be relied on. Before I move on to our commission update, I did want to mention just one other case that I talked about last year. Some of you may recall, because I'm sure you really held on to every case I talked about last year. There's a case called Cosby versus Drake Carpentry. It was a case that might have resulted in increased disability to our employers and insurers. Essentially, without rehashing that case, the commission under Chairperson John Larson indicated in dicta of that case that if benefits typically paid by the Second Injury Fund were to no longer exist, then that extra disability should in fact transfer to the employer instead. We've been monitoring that case for the last year. It was argued at the Supreme Court in October of 2018, and unfortunately, given that the employer was no longer a party to the case because he had settled his exposure prior to settlement, both the Second Injury Fund attorney and attorney Marshall Edelman attempted to dump on the empty seat in the arguments. Now, the Supreme Court's last hand-down date for decisions was April 30th. They still hadn't decided on this case. The next hand-down date is next week. So the reason I mentioned this case and why I talked about it last year is because it's quite the buzz case at the division.
around the hand-down dockets, or around the hand-down dates by the Supreme Court, people are, talking about it, trying to figure out if anyone's heard the first word that it's been decided or not. Depending on what the Supreme Court does, it'll either quash the issue and make the Edelmans be quiet for once, or it could ignite a storm. So we're monitoring it. We're trying not to be alarmist, but also cognizant of the fact that this case might be a big deal to us going forward. On that note, I do help organize the case law update within our firm. Our workers' comp practice group meets monthly. We go over, problem cases, problem opposing counsels, kind of issues we're seeing at the division, and we also prepare one page, so they're super easy to read, not too boring, case law summaries. If you want to get added to that list, talk to your attorney, talk to me. Happy to add you to that. Now, we thought in light of a lot of changes that have occurred between the addition of new judges and new commissioners in the last year, we could give you a quick update regarding some of those changes. Since April of 2018, 4 new ALJs have been appointed, 2 in Jefferson City, Bruce Farmer, and former Evans and Dixon attorney Melody Powell. There's been 1 in Cape Girardeau. Amy Young is a former defense attorney, and there's 1 recent one in St. Louis, Jason Tilley. We've also added Commissioner Reed Forrester as the employer representative. He's been on the commission since May 2018. I must say, based on some of the very passionate dissents he wrote under Chairperson John Larson, we're starting to feel some hope, some comfort there going in front of the commission because he is on it. His background is as a business owner and manager, apparently in the video rental chain. I'm assuming this is before Netflix and Hulu kind of changed our world. And then he did some kind of governmental liaison work before being appointed. There was also the addition of Chairman Robert Cornejo in August of 2018. The first decision he participated in was in October of 2018. He's an attorney. He graduated from Mizzou Law. He served as a state rep for 6 years in St. Charles and in Lincoln counties prior to his appointment by Governor Larson. So we reviewed all of the cases that have been handed down since Chairman's appointment through April of this year. It's about 44 cases. My little lawyer caveat here is that this is all public information. It's all available in the decisions that are published by the commission on their website. We simply took that information and organized it in such a way as to give our attorneys and our clients kind of a heads up as where we see the commission starting to trend. Overall, the commission has taken a more conservative approach. On this slide, we list all of the ALJ decisions by judge and organized by whether they were affirmed, modified, or reversed. Of the 5 reversals, 4 were in favor of the employer, where the ALJ had initially granted benefits to the employee, and the commission overturned that award. With regard to modifications, there was a lot less consistency as to who won. Further analysis of our data indicates that in recent months there have been less reversals as compared to the first 4 months where there were more reversals. Perhaps this suggests another shift back to the middle, but anything's better than the opposite side. On this chart, you may note that some judges have a number behind their name. That simply is the number of times they've gone up and been decided on. For instance, Judge Cheer had 2 cases that were affirmed, but 1 that was modified. Judge Mahon had 2 that were affirmed and 1 that was reversed. Okay, so this next slide has a listing of doctor opinions that have been found to be credible and persuasive versus not as credible or persuasive. Now you'll see that Dr. Valarich shows up as credible 5 times and not credible 7 times. So yes, out of 44 cases, 12 of his cases went up to the commission, so he's obviously doing well for himself. For those of you who don't know, Dr. Valarich is a typically claimant-retained IME doctor.
Typically.
Yeah, I think in his testimony he'll say like 99.9% claimant, but I depose him on Monday, so I'll ask again. You'll see that Dr. Bruce Schlafly has yet to be found credible by this commission, as he has had 2 findings on the not credible list. But to end on a positive note, Dr. Coyle, who taught us some good lessons today, and Dr. Cantrell appeared twice on the credible list and 0 times on the not credible list. lastly, we reviewed the commission cases for their findings regarding vocational experts. For those of you who aren't familiar, vocational experts are typically voc rehab counselors who look at the person based on their vocational history, their education, their prior injuries, compare that to the medical restrictions that have been placed on them, and make a finding as to whether they are employable in the open labor market. Our beloved and now retired James England was found credible 7 times and only appears on the other side once. His successor, Benjamin Hughes, is 1 and 1. Mr. Weem Holt, who typically testifies on behalf of the claimant, shows up 2 times as credible and only once on the other side. So some of you may have had a chance to listen to Chairperson Corneo speak in recent months. We're gathering from him that he is exerting an emphasis on the statute, as the Workers' Comp Act is a creature of the statute. If it's not in the statute, he does not want to make a leap to fill in what the statute has left out. So you have to remember that prior to being appointed, he was a state rep, and so we assume he's drawing on that experience in his new role. And that's all I have for you with regard to cases and commission updates. If you ever wanted to nerd out and talk about cases with someone, you know where to find me. Thank you for taking a break with me from the show, and I'll let you get back to it.
Thank you, Maria. Appreciate it. I think at this point it is appropriate to go back to Money Miles one more time. I think she probably needs to wrap this one up with her client.
Let's call this guy. I don't know why he likes FaceTime, but all right. Hey, Jack. Hey, yeah, I just wanted to check back in with you now that the civil case is closed. Right, no PI money for the PI. Circle gets the square on this one. Hey, remember, be sure to maintain your surveillance equipment, your doors, your locks, etc., as all are part of your compliance with reasonable safety measures under the Business Premises Safety Act we talked about with Lori. Yes, once you have that equipment in place, you need to keep it current and in good condition. You don't want to risk sabotaging any defenses you may have by canceling your surveillance contract. Right, especially because it doesn't cost you too much. Oh, wait, what? You're going where? No, stop going over there. Stop going to Jack in the Box. But look, hey, before you order, hold on, one more thing. What was in that bag? Oh, no kidding. All right. Until next time, Jack, have a good one.
Dear Mr. Tierney, we accept the fact that we had to sacrifice a whole Thursday morning in seminar for whatever it is that we did wrong. But we think you're crazy to make us write a brief telling you who we think we are. You see us as you want to see us, in the simplest terms, in the most convenient definitions. But what we found out is this, is that each one of us is an ex-con, an ambulance chaser, defense attorneys, adjusters, and a business owner. Does that answer your question? Sincerely yours, the Breakfast Jack.